go into old business and we'll vote on the applications. The only thing that I want to add is that it's very important that if you have any information to discuss, it has to be discussed during the first portion of the meeting. The second portion of the meeting is a public meeting, but it does not allow anybody to speak at the second portion of the meeting. The second portion is only for voting on the applications that we listened to during the first portion of the meeting. I don't know if everybody understands that, but if you have any questions, please raise your hand. If not, I'll go to the first application. And it's ZBA 2020-11, map 11-3, block 132, lot 19, 288 Beckley Road. This is postponed. Carrier Enterprises is appealing the decision of the zoning enforcement officer dated July 7, 2020 to deny a zoning permit for a building permit application for new construction of a single family house. This is postponed at the request of the applicant. The next item is ZBA 2020-12, map 113, block 132, lot 19, 288 Beckley Road. This is also postponed. This is Carrier Enterprises is appealing the decision of the zoning enforcement officer dated August 19, 2020 to deny a zoning permit for building permit application for new construction of a single family house. This is also postponed at the request of the applicant. Our next application is ZBA 2020-15, 697 Berlin Turnpike, map 10-4, block 132, lot 86. Kusum Shah, owner, member, Twin Spruce Motel, LLC, is requesting a variance for a southerly side yard of 13 feet when 25 feet is required in the BT1 zone, Berlin Turnpike 1, for Vernon zoning regulations. 6J for a detached 12-foot by 24-foot accessory garage to replace a 12-foot by 20-foot garage in the same location that was damaged. Speaking for the application. Come out, sign in, and have the microphone.
The signage is on the podium.
I have, if you don't mind, I have to take it out. I have some material which I would like to distribute, so.
I'll do it so that we're, yes, disclosure. Thank you.
Basically, I'm going to read what we have, and then if you have a question after, we can discuss it accordingly. Okay. We are replacing existing portable garage with a portable new garage. We have been residing and operating Twin Spruce Motel located at 697 Berlin Turnpike, Berlin, Connecticut, from last 14 years. We are law-abiding citizens. There has never been any complaint against us in past 40 years from the town of Berlin Police Department or Fire Department. Twin Spruce Motel is a 14-unit motel, and we operate the motel and also live there. The garage we need to replace is over 30 years old, and it has been there from 1987. It was damaged and destroyed by storm in October 2019. And I have some photographs which I gave to. Right, yeah. Our next door neighbor is wine merchant and spirit, and that's 1717 Berlin Turnpike. We have living fence, evergreen tree, which are over 12 feet tall, running between our property line. This enables both the neighbors completely privacy. The garage would be at least 15 feet away from the neighboring property line. Please see the attached photograph. Our neighbor on the other side of the property is an office building with the following office: the law office, real estate office, P&G Insurance Company office. Their address is 675 Berlin Turnpike. They are on other side of the motel and far away from the garage. There are no other property near to the garage. The old garage has been in the location from past 30 years, since 1987. We are requesting to replace an old damaged garage with a new safer one. The place where the garage is located has been chosen due to following reasons. The garage is used to store anything our customer leave behind after they check out. Also used to store AC unit. Sometimes our customer leave their belonging when they check out of the room. By law, we are required to store their belongings safely for 30 to 45 days after they check out, so that when they come back, they can pick it up. The garage is adjacent to our parking lot, and it enables us to roll and stop belonging to our customer on the dolly and store in the garage. The garage location is ideal for ease of loading the stuff in and out through the parking lot. There is no other secluded and safe place on the property where this can be done. Also, we use the garage to store AC units. We have to store them in the garage safely over the winter so they can provide AC to our customers in the summer. This is the reason why we think the current location is the best place for new portable garage as well. We are all aware of the cold winter we have in Connecticut. When it snows, we have a parking lot plowed, and thus we have clear pathway to garage. This enables ease of transportation for our customers. We also have generator that we use for the motel storage in the garage in case of power outage. When our customers come back for their belongings, they are able to bring their car to the garage in the parking lot in the back and transfer their stuff from their car. The safety and comfort of our customers has always is our number one priority. Also, with the current coronavirus pandemic, for the safety of all the people, I have to store the belongings the customer leave behind, away from everything else. I cannot store their belonging anywhere near the room. The current location of the garage is perfect for this as well. It is all the way in the back, away from the main building, adjustment to a parking lot. It is the countless pickup location for our stuff, for the guests behind, which help in the pandemic. New portage garage has been purchased from Doug Marcelli of Pine Creek Structure, 1865 Berlin Turnpike, Berlin. And the site work is done by J.R. and Son Improvement, Plainville. Over the span of 14 years, we have maintained very friendly and cordial relationship with our neighbors. They have never complained against us. We have very outstanding record with the town as well. If anybody has a question, the main thing we are taking out the old portable garage and putting with the new one. New garage is only 4 feet more. Old garage was 12 by 20 feet. New is 12 by 24 feet. It is about 13 feet from the next door property instead of 25 feet. Thank you very much.
Thank you, Mr. Shah.
Yeah,
Is there any reason why the garage is 4 feet larger, the new one?
from the very beginning, it was a small garage, little bit small. That's why we get for the bigger garage. There is no, and we need that because now the business is increasing. Not only that, with this coronavirus, we have to keep the distance between people belonging. That's the reason why we have little bit bigger garage than what it used to be.
Thank you.
Mr. Shaw, before you leave, can you hear me? On this diagram right here that's on screen, did you consider using the blue area for the proposed replacement? Because the blue area, as the town has shown us, these are from the staff comments, I think. The town has shown us that blue area would be a conforming rebuild.
You mean they want us to do it here?
Yes.
No, because see, there's a garage here, and the pavement, the slope would come out, and very hard to pull out the car, and there won't be much room here to go behind.
Okay.
And this is the location we decided before about many years ago, this one. So we have a room here, so we can go in the back also, in this side of the area. And the car when comes out, and when we have to put anything or anything like that here, and the snow plow can plow the snow here. So there is enough room for and we have 2 rooms here, customers' rooms, the guest stays here. So sometimes they have cars, they can park it, so that's why we decided that place, and at that time town agreed upon.
Okay, and the second question is, I read, I think in the material that the site work for the replacement has already been completed.
Yes.
So you completed the site work in anticipation of getting a variance then?
No.
What happened, I applied for the permit and I didn't hear from the town. He sent me the email. It doesn't say town of Berlin. Because it doesn't say town of Berlin email, I received so many emails which I didn't know it come from the town. So we already took care, we ordered it, we already paid the half price, we already done the site work, And when we are ready to go, I receive another email. And then I know that it's from the town. So I
Otherwise, we
didn't
would
know
not
it.
have done it, anything.
Yeah.
That
That's
was
the
done.
only reason I did the one. Otherwise, I would have gone for, even though it's so much obstacle, because we need little bit bigger garage. But
Either
I
way,
would not have done that.
either way,
if
it
I
still
was
had to come
knowing-
down,
I'm sorry?
the old one still needed to come down either
Yeah,
way.
it was totally, because
It's
of the
totally
storm
gone.
last year,
Right.
it was, the
Pictures,
tree
yeah.
came out and then it was like that.
Yeah, that's
And
the
it was
garage.
sitting there
Yeah.
for many months because of the coronavirus and all those things.
Yeah.
And the winter, nobody was open, so we couldn't go and do shopping and get another one.
This is the where everything was the tree, and the tree fell down and took the garage with it. And the tree roots were inside the garage.
We would not have one.
Yeah. And that's what happened.
Thank you.
Thank you.
Additional questions?
No more questions?
All right, make a motion to close the hearing on this application. No, I'm sorry, staff comments.
This is just to remind you to have people speak one at a time because of the record and the
Right.
recordings, we really need to have clear understanding, so when we have applicants talking, you can try to remind them one at a time.
Okay.
The board. And Adam is going to take care of the staff comments, he's
Insofar as the staff comments, largely the speakers spoke to what existing conditions were and why they're replacing in this similar location. The one thing that, just going through the records, there were various applications throughout the years for this property in terms of PZC site plan amendments and zoning board of appeal variance requests. One note that was from a request in, I believe it was 1986, when they were trying to do an addition of more units, was to prevent blocking rear access to the rear of the property, and that was the basis for denial of that setback variance. So as part of that, when I was speaking to them when they presented the application, they indicated that's why this additional staff developed schematic is shown, where I had asked about the blue area, and they had, as they said, indicated the front of this garage and the person door on the rear of this portion of the garage, and to prevent blocking that flow of access there.
Right, so to clarify, there is an existing variance for the current site pad, the pad of the previous garage.
No, there's not we did not find the building permit or the existing non-conforming garage as far as we could find. Not find the building permit for that.
Okay, but it was a non-conforming use at that time.
The lot is tiny, everything is basically
Yeah.
non-conforming to that lot.
Yeah, I understand that.
Can I clarify a little bit?
Sure.
That garage was there from 1987. Town has all the record that garage was there. I don't know, it's a long time ago, from 1987, And the town has a record, the garage is there, and I think that answers.
It was on the 2003 plan that went to the Planning and Zoning Commission for approval for a site plan amendment of the this area here, this garage. This is a snippet of the PZC showing the PZC approved plan for this garage. They had this there, which corroborated by assessor's card showing that garage existing in about 1987.
Okay, I'm all set. Any comments in favor of the application? Any comments in opposition to the application? Any additional? Okay, now I can ask for a motion to close the hearing.
Motion to close the hearing, or
Second.
this item?
I'll second.
Have a motion made and seconded. Any discussion? All in favor?
Aye.
Aye.
Okay, so moved. Next application. ZBA 2020-16, 65 Savona Road, map 14-2, block 69, lot 85. Vipul Patel is requesting a variance for a northerly front yard of 25 feet and 35 feet is required in the R15 zone for Berlin zoning regulation 5810 for a second-story addition of an existing attached garage. Property is on a corner lot, the requested variance along Colonial Drive. Speaking for the application,
Thank you for feeding us all. My name is Sarah Patel, with my husband Vipul Patel. The first thing, we're not increasing the footprint of the house in any way, we're simply adding a second story. But because the house is now beyond what the setback would require of current regulations, we are requesting the variance to put the second story on the existing structure. So what we would like to do is make the current garage a master suite and add 2 bedrooms above that for our children. Our family has grown and the house is not quite big enough for us, but we really love our neighborhood and we'd really love to stay there. Because we're very happy with our son's school and all the things. So my husband and I can speak a little bit more of the technical pieces of it, but that's pretty much the gist.
Right, so the existing garage is 25 feet from Colonial Drive right now. I know the setback is around a corner lot, it's 35 feet. So like Sarah said, we're not expanding the foundation or the footprint at all, we're basically just going 1 story up. Like she said, we're putting on all our bedrooms on that side of the house, and existing bedrooms will
Become living space.
become living space like an office and playroom. So that area worked out the best for the layout of the house, and that's how our architect drew it up. Just to make it the most functional versus trying to add on a different area.
Right, and I also think, and it's noted on the plans too, you can see originally Colonial Drive was not there when the house was built, it was a proposed road at the time. So you can see that, the yard would have been quite a little bit bigger, and I think that they, took away for that proposed road. Because, well, anyway, you can see that, so, sorry.
what about the height of your addition? Is it gonna be higher than the existing house?
Yes, so we're adding, it will not be a full second story higher because the garage is currently lower than the actual ranch part of the house. But it will go above the existing ranch roof line.
Right, the garage right now is about 24 inches lower than the rest of the house. And then adding a 1 story, which is I believe 8 feet.
Right, that's the roof, yeah.
Right, 8 feet. But we're keeping the same pitch of the roof, so it's not gonna add on more than the 8 feet.
Right. Do you have any other questions?
No questions?
Thank you. Staff comments?
They pretty succinctly identified it. The original setback appears to be just from there not being an existing road, so it wasn't front frontage at the time. So it's just existing non-conforming, maintaining the existing non-conforming setback on the side.
Understood. Any comments in favor of the application? Public? Any comments in opposition to the application? Now I'll make a motion to close the hearing on the application.
Second.
Motion made and seconded. All in favor? Discussion? None? All in favor?
Aye.
That's closed. Last application before going into the full business and then the remand is ZBA 2020-17, 164 New Britain Road, map 3-3, block 24A and lot 38. Urbano Econ, owner of Berlin Food Mart, is requesting the sale of alcoholic beverages to Berlin Center Regulation 11B for an off-premises grocery beer liquor permit for the Berlin Food Mart located at 164 New Britain Road, property zone CCD1. Speaking for the application.
I believe they're attending via WebEx, so I'm gonna unmute them. Urbano, are you there? Hello?
Urbano?
Folks, I see, my name is Mohin Kapurwala, and I've been going back and forth with Adam and Maureen on this. I know she's on, and she was on a little while ago, and I still see her letter there. So I'm not sure what's going on. Gulbano, are you there?
Yes. वीडियो ऑन तो होता नहीं है Yes. बोल जोर से बोल बोला ना
Urbano, can you
Hello.
explain your case?
Yeah, Gulbano, can you explain your request?
With the board's permission, would it be okay if I were to speak on behalf of Gulbano? Because I'm familiar with the facts, and she's asked me to speak to the board on her behalf, if that's all right.
He's a consultant facilitating the paperwork and such for the liquor.
Yeah, as long as you've got something signed or if you've got approval from her.
If the board so pleases, we could probably get verbal approval right now.
Sure.
Gulbano,
Yes.
they want to know, is it okay if I speak to them for you?
Yes. It's okay.
Okay.
Thank you. Thank you very much, members of the board. This is a request to be able to apply for a grocery beer permit for Berlin Food Mart. This store is under new ownership, and historically, this particular location under the prior owners, Berlin Mini Mart, had a grocery beer permit. It was grocery beer permit number LGB 0015457, and I know the prior owners had issues with signage, and Adam's been very helpful in this whole matter. I've been speaking to Maureen about this. These folks are new owners of the business, and they've taken down the signs as required. And my clients even sent me some pictures from this afternoon showing that all the signs had been removed. And I forwarded that on to Maureen as well as Adam. All we're asking for is to be able to apply for the liquor permit in a location that has previously and historically had grocery beer permit. And in terms of compliance with all the mailings, I've already sent out the mailings to the neighbors, 71 neighbors. I've emailed a copy of it to Maureen as well as Adam. We had put up the signs required, and I've sent photographs of those as well. If there are any other questions I can answer for the board.
Actually, this is Commissioner Whiteside. So staff, have you confirmed the signage issues are resolved?
We just received some photos today, so I've not had a chance to go out and look at everything there. But what we're seeing today largely addressed the items that I had identified in a detailed email with photos showing what they needed to take down. So again, I have not field verified yet, but what I saw in the photos looks pretty good, especially compared to all the million energy drink can signs and stuff that were there before.
And the previous location had a beer permit as well.
Same property owner, just a new business owner.
Okay.
But this is ongoing.
So
if I may just expand on that, you've seen this every couple of years for the last 5 or 6 years or so. This was a property that, I believe the original permit dates back to a 7-Eleven that was in location.
Right.
They had, it's whether, I think there was a distance requirement that may not currently be met. But again, it's an existing condition for existing alcoholic beverage sales that have been in existence for many years. And like I said, you've seen this for the One Stop Food Store, like Adam's report indicates, the One Stop Food Store, 7 Stars LLC, the Berlin Mini Market, and the current owners are requesting the same. They will have to show that they meet the requirements for the grocery beer permit. You might remember one of the meetings, you had extensive pictures and presentation with regard to the grocery aspect. That is part of what's monitored by the state. When they go for whether they meet the qualifications for the state permit, that is part of their criteria to have to provide all that information, and it's here as well. I understand some of the things.
If I may address that point, ladies and gentlemen, with the application, I did submit photographs of the interior of the store showing massive and shelves upon shelves of groceries within the store. So I completely understand and appreciate the point made that it has to meet the statutory requirement for the state for it to be eligible for a grocery beer permit. And based on the photographs and based on what was submitted, I am of the opinion that it does meet that requirement. And the second thing I would like to point out to the board members is, and I was very clear about this with my clients as late as this afternoon, when I spoke to them, as this property is historically under other people's ownership, have had issues with sign violation. We have to be able to assure the board members that we're going to comply, not just get the signature and be done with it and have issues with the violations. But I told them we have to be able to be okay and make sure that the board members understand that you are not going to go down the same road that your predecessors had. And between what it looks like this afternoon from when I first looked at it with all the massive signage, tremendous difference. And they understand that this is in their control and their hands, and they are going to comply and make sure they do not go afoul of the signage requirements.
Thank you. Any other questions?
Nope.
Any other comments? Any comments in favor of the application? Comments in opposition? Not?
I don't see someone, I received a call today and he doesn't appear to be here. Chris, is any of you, Chris? No. So the owner of the gas station at 152 New Britain, the Citgo, that's right next door. He reported the owner, Chris. He called and discussed just for a moment with me, saying he had some opposition to the liquor permit application. He would not say what that was. He suggested he was going to be coming either in person or via WebEx, but he's not here. But just for the purposes of making that on the record, I did receive a call in opposition from the owner of the Citgo.
Would I be permitted to address that opposition issue?
Please go ahead.
Oh, because gas stations, and I've been doing this as a consultant with liquor permits for well over 15 years. Gas stations, as a general propositions, it's very difficult for them to get a grocery beer permit under the statute, because you have to be primarily engaged in the sale of groceries, and gas stations are unable to ever meet that requirement. So if the owner of the gas station, if they do have any objection to it, it might be that they might consider selling beer, but it being a gas station, that is a very difficult threshold to meet because of the requirement that 51% of sales have to come from groceries. So I think that might have been his only objection.
Thank you.
Thank you.
Any other comments? Have a motion to close the hearing on the application?
I'll second.
Motion made and seconded. All in favor?
Aye.
No discussion? All in favor? Aye. So moved. Okay, getting ahead of myself, but I think what we're gonna do is go back and go into, old business and go over the applications we just heard, and then go through the minutes before we go into the remand session. So, going back to application ZBA 2020-11 and ZBA 2020-12, Carrier Enterprises is appealing the decision of the zoning enforcement officer dated July 7th and August 19th, 2020, to deny zoning permit for building permit application for a new construction of a single-family house. This is postponed at the request of the applicant. Next application, ZBA 2020-15, 697 Berlin Turnpike, map 10-4, block 132, lot 86. Susan Shah, owner member. Twin Spruce Motel LLC is requesting a variance for a southerly side yard of 13 feet, when 25 feet is required in the BT 1 zone per Berlin zoning regulation 6J for a detached 12-foot by 24-foot accessory garage to replace a 12-foot by 20-foot garage in the same location that was damaged. I have a motion to approve this application.
I make a motion to approve.
Second.
The motion made and seconded. Any discussion? Any other issues with respect to other caveats? Nothing? All in favor?
Aye.
Aye.
Okay, that's approved. ZBA application 2020-16, 65 Savona Road, map 14-2, block 69, lot 85. Vipul Patel is requesting a variance for a northerly front yard of 25 feet when 35 feet is required in the R15 zone for Berlin zoning regulation 5810 for a second-story addition above an existing attached garage. Property is on a corner lot with a requested variance along Colonial Drive. I'll make a motion to approve this application.
Second.
A motion made and seconded. Any discussion? Any other concerns? Hearing none, all in favor?
Aye.
The application is approved. And our last application on the regular business here is the ZBA 2020-17, 164 New Britain Road, map 3-3, block 24A, lot 38, Lubano Magani. Owner, Berlin Food Mart, is requesting sale of alcoholic beverages approval for Berlin zoning regulations 11B for an on-premises grocery beer liquor permit for the Berlin Food Mart located at 164 New Britain Road. The property is zoned CCB1. I have a motion to approve this application.
Make a motion to approve.
Second.
I have a motion made and seconded. Any discussion? All in favor?
Aye.
Aye. Okay, that's approved. I'd like to go through the minutes. We have minutes from a lot of meetings.
Tony, you may want to let the applicants know that we won't be discussing their items further.
Oh, yeah, and we won't be discussing any of your items. They've all been approved so far. And if you wanna leave, you can leave. If you wanna stay, you can stay. It's a public hearing, so it's up to you.
Thank you.
Thank you.
Enjoy the night.
Agenda, please. Yes, you do.
We have minutes all the way back.
February.
So you do on each of the minutes, sets of minutes, have enough people to vote on them? They require a simple majority, that's 3.
Okay. First set of minutes is from February 25th, 2020. This was the
So I would make a motion to approve the minutes from February 25, 2020 meeting.
Second.
Okay, we have a motion made and seconded, any discussion? All in favor?
Aye.
Aye.
Okay, that's approved, that's a long set of minutes. Regular meeting minutes, April 28th, 2020.
Motion to approve those minutes?
We have a motion made to approve the minutes, second? I'll second it.
I'm sorry, who seconded it? Ryan?
I'll second,
We will talk in.
we both seconded.
Choose.
Pick one.
Okay.
That's also a long set of minutes.
Like to have an attention to detail.
There you go.
I think Fran did those minutes. June 23rd, 2020.
We
You have to vote.
Oh, I'm sorry, we didn't vote on that?
Mm-mm.
Make a motion to approve those minutes.
No, it's February
The motion
20th.
You did that.
Oh, I thought we did vote on it. Oh,
You had the motion to approve was made by Corey Whiteside and seconded by Chairman Frank Langria, and now you need to vote
all in
on.
favor?
Aye.
I'm sorry. My bad. June 23rd, 2020.
Motion to approve?
We have a motion to approve.
Make a motion to approve the June 23rd minutes.
Wait a second.
The second?
We have a motion made and seconded. I'm just going through the minutes to make sure right ones, okay? We have a motion made and seconded. All in favor?
Aye.
Aye, it's approved. And we are up to September.
Motion to approve September 22nd minutes?
I'll second.
We have a motion made and seconded. Okay. Now we have a motion made and seconded for the September minutes. Discussion and, all right. We have a motion made and seconded for September meeting, all in favor?
Aye.
Aye.
Takes care of all the minutes. It's about a half an inch of paper. Well, I actually read them when we got them, but I wanted to just go through them again as I was flipping through, I lost track of what I was. Okay, at this point, we finished all the regular meeting business. We have a large package in front of us for 1005 Kensington Road.
Well, I'm gonna just do this.
Yeah, just the chairman and Will and I.
Tony? I'm gonna, since I cannot participate in the remand hearing, I'm gonna excuse myself from the remainder of the meeting.
Oh, can I do that? No.
Okay, thank you. I didn't understand.
Well, we got it now.
Thank you.
You go, I'm just gonna speak. Thank you.
I'm good, Chairman, I'm gonna take care of them signing in now, they did ask to sit so that they have paperwork and whatnot, so.
Do you want me to read the agenda item for the record, or?
In what, if you would, wait, entertain us for 1 minute to get this
No problem.
paperwork established
Absolutely,
and organized.
I'm very flexible with that. Okay.
Thank you.
my name, just for the record, my name is Jennifer Capola. I'm from Corporation Counsel's Office in D'Onofrio. And I am here tonight for this remand hearing. I am representing the board, that's the capacity in which I serve. And I just want to go through a couple of housekeeping matters. We do have exhibits that we do need to mark for the record. Again, this is a remand hearing. So just for the record, I'm going to mark two exhibits. The first is the court's memorandum of decision from January 15th of 2020. And then your reading packet tonight, I'm gonna go through what that includes because it is quite detailed and it's important that it reflects on the record the composition of it. There is correspondence from me dated October 24th, and it does set forth for you, and I'm gonna go through this too. It does set forth for you the direction from the court on the remand at page 2. As indicated at page 2 and further on in the correspondence, there are a number of documents that were attached. Those documents which are mentioned in number 2 there. The designated contents of the record. I just want to explain to you what that is, because this is actually, despite the fact that our firm has been corporation counsel for some time, this is actually the first time that any of you are ever seeing me. And you've not needed me, which is a good thing. So I just want to explain to you that the way the record gets returned to the court is we do a certified list of record items, and then it's counsel's responsibility for both parties to come to an agreement about what should constitute what's known as the designated contents of the record. Because we don't want our very busy judges to be looking through a pile of paper unnecessarily. So if there's items that we can eliminate for them and just have them look at certain set documents, it just makes everything more efficient for everyone, and we can focus on the legal issues that are important to focus on in a particular matter. So what you have, again, included in your packet in terms of designated contents are as indicated on page 2 and section 1. And again, you've got, you were given copies of the record items 1 through 10. Record item number 11 was the zoning regulations that were in effect at the time that the appeal application was brought by the Mitchells. There was an excerpt that was included with your meeting packet from the zoning regulations, but the entire copy of the zoning regulations, I didn't want to have to, burden you with the distribution of that. That will be separately marked. So if anybody does want to take a look at anything else, we do have the full copy here for you. And then beyond that, I also provided you with a copy of the documents that were submitted by Attorney Griffith, again representing me and Cynthia Mitchell, who are the applicants who brought an appeal of the subject cease and desist order. And those are new documents because this remand hearing, it is a new hearing. And so those are new documents that are being offered on behalf of Mr. and Mrs. Mitchell. And then I also gave you a copy of Connecticut General Statutes 8-7 for 2 reasons. Number 1, because it is referenced in the remand section of the court's decision. And number 2 is because it is the statute that directs what the procedure is supposed to be on appeal, which is obviously why the court referenced it. So that is in your packet as well. So we're gonna mark all of this Again, my correspondence with all the attachments as exhibit number 2. Then, again, a full copy of the zoning regulations, which was record designated person, the record item number 11, will get marked separately as item number 3. And then, we were gonna turn into I only have my copy, I thought you would bring. Thank you so much. Do you need to use my copy? Did you need to have one? Okay. The next item is a revised proposed findings of fact that is being offered by council, and he did bring copies for you. So that will actually be, we'll mark it as exhibit 4. He's marked it as item number 21. And again, that's going by his numbering from the prior hearing and then the additional documents that he submitted. He had submitted on Friday items number 17 through 21. Again, this is revised item number 21.
I think the effort was to continue the items of record as we submitted to the court, to just continue it. So there is some order to it.
This is new tonight.
This is new. He did revise his proposed findings of fact. Again, it was number 21 in what you received on Friday. So, and he'll explain why, a very specific reason why he's revised that. And it has to do with the next record item.
Excuse me, can we pull that out? Should I be labeling this with the exhibit number 4 or no?
Not exhibit number 4 is fine. I know the purpose for which you did it.
Okay, no, that's fine, I just wanna make sure I'm doing it
We'll work
correctly for the record.
We'll work it out on our end. And then lastly, we have 3 black and white photocopies that have been marked as item number 22. Again, these are being offered by the Mitchell's Council, and they are black and white photographs of some photographs that Mr. Mitchell took today. He only has 1 copy, so I think when it comes time for council to review these, perhaps the best thing, so that you're not passing back and forth papers, is to just show them individually, if you would. We have to be cautious about what we're doing in terms of interaction. So we'll have Maureen mark these as number 5.
How many
And then
photographs are there?
again, there's just 3 copies that will consist of exhibit number 5. So just lastly, I want to point something out to you. you noticed, and this is reflected in my correspondence, again, dated October 24th to you, that is exhibit number 1 with all the attachments, again, comprising your pre-meeting packet. You had included in there a notice of paper filing. And what happens is, in this day and age, when we file a record now with the court, we e-file it. We electronically file the record. Now, that's not necessarily ideal in the business of the zoning commission and board, okay? Because sometimes we can't electronically reproduce something with the best quality. So we actually had an issue with some of the record items that were offered in the first hearing. So we needed to paper file those. And those were record items number 2, the drawings that were offered. Number 3, which consisted of the memorandum of staff comments prepared by your planner, your CEO, Maureen Giusti, and the departmental file that followed. And then item number 8, which consisted of a number of items, including color copies of photographs that had been offered by Attorney Griffith, again at the prior hearing. And then the zoning regulations, because we don't upload the zoning regulations because they're 250 pages. And to do that to our judges is somewhat unfair to have them have to scroll through. So we do provide them with a paper copy. I did obtain from the court the originals. We did a joint motion, and the court ordered the release. So we do have those originals. You can look at the drawings if you'd like. Attorney Griffith may hold up certain of those original exhibits. And again, the point is that they could not be adequately reproduced. So, you'll see in your copy of, for example, exhibit return of record item number 8, that some of the photographs are a little bit dark. So we do have the original for you to look at if you'd like. Council would like to show them to you. We have those, and I told Attorney Griffith I basically have to sign in blood to get the release of them, and I'm responsible for taking them back and attesting to the fact that they're in good order. So let's not disturb them in any way and keep good track of them. I'm gonna go back to my seat, and Attorney Griffith and I discussed the fact that I'm gonna just initially take you through what the remand order is, and again, that's on page 2 of my correspondence to you. So if you get there while I walk back, it's at the top of the page. Okay. So I'm gonna read it to you. Please follow along. I know that all of you have read it before, and certainly Attorney Griffith and I have read it multiple times, but it's our focus for tonight, so it's important that we listen to the instruction of the court. This court finds that the board has not properly considered the plaintiff's assertion and evidence of a pre-existing legal non-conforming structure and use concerning the basement apartment. As such, court remands this matter to the board for further consideration. Upon remand, the board should consider the evidence presented by the plaintiffs concerning the timing of the construction of the basement apartment in relation to the applicability of the zoning regulations as they changed over time. Okay, so let's stop there. The board should consider the evidence presented by the plaintiffs concerning the timing of the construction of the basement apartment in relation to the applicability of the zoning regulations as they changed over time. And Judge Cordani had a footnote there, right, which I set forth here on page 2 in brackets. It states, the current record contains evidence to support a finding that the structure of the basement apartment was legally constructed in the 1950s and has remained so over time. Concerning the use of the structure, reasonable inferences may be made, and consideration should be given to the regulatory definition of dwelling at the time that the basement apartment was originally permitted and constructed. However, the board is the finder of fact here and may make any reasonable findings of fact that find substantial support in the evidence. In this regard, the board is reminded of its statutory obligation as provided for in General Statute 8-7, and he has subsection 3. And I'll make a comment about that shortly. It goes on. The parties may present new evidence at the remand hearing. And so he's ordering essentially a new hearing because he's finding that you have not properly considered by making specific findings of fact. If the board determines that the basement apartment was initially constructed as a permitted legal structure and use, then the board should further consider whether the basement apartment has remained so constructed and used over time. The board should make reasonable inferences from the evidence presented. In considering the evidence presented, the board should consider the word dwelling at the time of the initial construction of this house provided for up to 2 families. Based upon the board's factual findings after further consideration at the remand hearing, using the evidence presented and reasonable inferences therefrom, the board should then conclude whether the basement apartment is a pre-existing legal non-conforming structure and use or not. Only after determining and considering all the foregoing can the board determine whether or not to uphold the cease and desist order. So let me just say a few additional things instructionally. So again, this is my first time with you. We've not had a matter where we've discussed pre-existing non-conforming uses. So how does something become a pre-existing non-conforming use? It becomes a pre-existing non-conforming use by being legally allowed first. Okay, so that's important that you keep that in mind. Okay? So the court is saying, go back in time and determine, was this legally permitted at a period of time? And then, did it continue? Did the use continue on from that point? Okay? Because the idea is it was legally permitted, and then the zoning ordinance, that's what we used to call it way back when, or the zoning regs changed and then made it non-conforming. Okay? So it's legally allowed, reg or zoning ordinance changes, but it still continues. Okay? And then you can make a final pre-existing non-conforming use. And then just in terms of, I gave you the case law that I did because he puts in there, you've got to consider, did it continue for a period of time? So, you've got to consider, was the use actual? That's why I gave you Wink. So to be a non-conforming use, the use has to be actual. It's not enough that it be a contemplated use, or that the property was bought for the particular use. The property must be so utilized as to be irrevocably committed to that use. To be irrevocably committed to a particular use, there must have been a significant amount of preliminary work done on the property prior to the enactment of the zoning regulations, which unequivocally indicates that the property was going to be used for that particular purpose. And then I gave you a appellate court decision in Cumberland Farms, an often cited case. Judge Lavery, one-time member of the appellate court, wrote the decision. And I gave you that specifically because not only does it explain and it cites the Connecticut Resources Recovery Authority versus Planning and Zoning Commission case that for use to be considered non-conforming, it has to possess 2 two characteristics, again, as I just articulated to you. First, it must be lawful, and second, must be in existence at the time that the zoning regulation making the use non-conforming was enacted. But it also talks about abandonment of a use. Again, this idea, because it's another part of the evaluation that you have to do, that it determine, was this use continuing? Abandonment is a question of fact, which implies a voluntary and intentional, and this is at the bottom of page 4, this last paragraph. Abandonment is a question of fact, which implies a voluntary and intentional renunciation. Nevertheless, the intent to abandon may be inferred as a fact from the circumstances. Mere discontinuance of use where there is no intent to abandon is not enough. To establish abandonment, the intention on the part of the owner must be to relinquish permanently the non-conforming use. Because the conclusion as to the intention of the landowner is an inference of fact, is not reviewable unless it was one which the trier could not reasonably make. So, last comment I want to make, and then I'm going to turn things over to Attorney Griffith and Mrs. Giusti. In terms of the citation to 8-3, or 8-7 rather, you have 8-7. This is the statute. Just hold it up. You want to get to this document. And if you look at the second page 252.
Sorry, Jennifer, is that in your,
It's in your packet. It's
this one?
No, it's a separate document.
It's
like the
It's
It's way back.
it's in the back. It was the second to last.
Alright, I got it.
So it's Connecticut General Statutes 8-7, he cites it. He cites subsection 3, I think maybe, I don't know, sometimes they dictate things, I think that was an error. I think what he was meaning, and I'm sure Attorney Griffith is gonna agree with me, because he always does. At the bottom of page 252, probably about a third of the way up, and this goes to, again, I said to you, 8-7 is your procedure that you're supposed to follow when you're considering the types of applications that this board hears, when you're considering an appeal of an action by the ZEO, or you're considering a variance application. It says, if you could get to that second to last, third to last sentence, where it says, whenever a zoning board of appeals grants or denies, do you see what I'm talking about?
Mhm.
Whenever a zoning board of appeals grants or denies any special exception or variance from the zoning regulations applicable to any property, or sustains or reverses wholly or partly any order requiring a decision appealed from, it shall state upon its records the reason for its decision in the zoning bylaw, ordinance, or regulation which is varied in its application, or to which an exception is granted, and when a variance is granted, describe specifically exceptional difficulty or unusual hardship on which its decision is based. So, regardless of whether you're acting on variance application, you don't need to get into hardship, because that's not part of this appeal order. But when you're acting on a variance or an appeal, okay, you have to indicate on the record, shall state upon its records the reason for its decision, okay? So the court took issue with the fact that there was not a collective reason for the denial given. And so I just caution you about that. It's important not to forget to do that. He's given you some very specific direction in terms of the findings that you need to make in this circumstance. So he's guided you with that remand language in terms of, generally the topics that the decision should be focused on, okay? But just when you go to act, and I'll remind you, because that's why I'm here, if you forget, but when you go to act, it's important that as part of your motion that you collectively state why you're acting one way or the other. So why you're acting either to hold or reverse the again, cease and desist order of Ms. Houston. Okay? So that's all I have to say, and I think we should get started with the new hearing. Thank you.
Members of the ZBA, my name is David Griffith. I am returning before you again and representing Liam and Cynthia Mitchell. We are here in appealing a cease and desist order. And as Jennifer has already said, but I'm going to state it again, we're here based on an order from the judge of the Superior Court. And he basically has asked us to come back here and that the board should properly consider the claim of Mr. and Mrs. Mitchell that the use of their basement at 1005 Kensington Road as an apartment pre-existed the change of the Berlin zoning ordinance. And that change occurred in 1962, an important date. The board must also consider whether or not that use and the structure continued on from that date. And it's my intention tonight to review with you some of the prior evidence that's been submitted. I would ask you to consider there's a narrative that I've put in evidence already for your consideration that it gives you an overview, but I want to focus with you on new information and new evidence that we are presenting to you tonight, and then some review of prior evidence. And obviously, if you have questions, we'll address them. A very important piece of information and evidence that we have provided you tonight is going to be, and I would refer you to package item 5-2, which is the packet of documents that I've submitted, and this is the new information for you. And in particular is a sworn statement of facts from a Kevin Sear, should be the first document in that package.
So you have it, excuse me, David, it's been labeled for you as documents submitted by Attorney Griffith.
Got it. Yeah. Everything you right? You good? Okay.
And the importance of that document is that we, through Mr. Mitchell, were able to find Kevin Sear. Kevin Sear is the son of the owners of the property in question, and they owned the property from 1960, an important date prior to the time the zoning ordinance changed, until 1981. And I would refer you to the statements that he's made, which is basically that during the entire time that he lived there, that the basement was rented out as an apartment. And that in addition to that, that there did come a time in 1969 or 1970 where there was a fire on the property, and there was a fire on the first floor. The Sears moved out for a period of time and rebuilt the if you will, the main floor of the property, but then continued on renting the basement apartment until they sold it in 1981. In addition to that, he has stated that on the property there is, and Mr. Mitchell will talk about it further. I'm going to ask him some questions to hear from him, but there is a separate garage bay that exclusively serves that basement apartment. And what we mean by that is that there is a door from the basement that goes directly into the garage. And it is where if the renter had a vehicle, would park there. In addition, we have also provided you with a statement of facts from Liam Mitchell. And that is the second document in that packet. Wanted to make sure that you all are looking at that.
What item number is it?
19.
Yeah, item number 19.
Okay, thank you.
And I'm just going to go through with this, with Mr. Mitchell, some questions in regards to this sworn statement. And he's going to expound, clarify some of the things that he has said already. So just again, we talked about Kevin Sear. And you spoke to Mr. Sear directly, did you not? And you proceeded to get the statement from him. Yeah. It's your understanding during that time that the basement apartment was rented out. Now, in regards to the original construction of the property, let's start with the foundation. One of the statements you make is that the way the house was originally constructed is it was set up to be if you will, a basement dwelling, basement apartment. And I think you basically start with how the foundation was originally poured.
Yeah, there's, between the plumbing and the foundation, it's obvious that especially the way it's laid out, it's very difficult to make a apartment after the fact. You have to do a lot of demolition in the basement in order to accommodate to make an apartment. But there was accommodations when this was first designed that there was full intention of having a secondary apartment. And when they poured the foundation, they allowed for openings, and the way it's laid out, plumbing wise, which the building inspector had looked at because of the way there was crowning in the floor where the plumbing went. And that all had to be done before, as you see in construction, that they'll pour the foundation and then they'll put in the plumbing, rough plumbing, and then they'll pour the slab over the top, and then they'll build whatever they're gonna do. It's very important that all that base plumbing, you can't share first floor with basement plumbing. It's plumbed totally different. The vents have to be arranged a certain way, and it's defined in some of these pictures of where the walls are and how the bathroom was set up, that it was all poured at one time.
So we're gonna come back to the plumbing with some photos that you've taken, but let's talk about for a moment. Were there openings besides an opening between the garage and the basement apartment?
That was the front door.
So there's a front door into the basement apartment?
Yeah. And the garage opening. It also had poured openings.
And how about the garage itself? Was the garage itself outlined by the foundation in cement?
Yeah, they're all preformed walls, except one. You know, the outline of 90% of this building is all, I mean, that's, I guess, what the family did, I don't know. his construction. He was a cabinet maker by trade. So he probably knew somebody, but it was all poured in one pour, so to speak.
And how do you know that that original plumbing that was in the slab, was connected?
Well, as a plumber myself, there's only one way to do it. And as the building inspector looked at it, he did not see any cuts where the plumbing went. If you were gonna modify, I don't care how old it is, if it wasn't off the original pour, there's no way you could hide that you cut the concrete. So, and there is no place where there's been any modifications to the plumbing because everything goes from the first floor down through the second, down into the basement and buried. So there's no way you can alter what's going on the top or the bottom without altering the floor.
And when you say the plumbing was connected, was it connected to any fixtures in the bathroom downstairs?
You mean in the basement?
Yes.
Yeah, they were all fixed, old type cast iron, lead and oakum type pipe, which is not done today. Do things differently, but they were all poured and covered, and there is pictures that show where the walls went, and you can see where the cement was sealed right around it, and there was no effect. If you tried to modify that, there would be a crater, and you would see a different layer in there where the cement, it wouldn't be smooth and then to the fitting. There'd be another crater in there if there was any alterations.
And it was connected to, was the plumbing connected to a kitchen sink?
Yes, actually it went through the bathroom and then went to a 45 into the kitchen sink. And he came up and vented out that.
Coming back to the doorways. Let's start with the exterior door. Was the exterior door, was the exterior door framed at some point?
Well, yeah, from original, I mean, you could tell by how old it is, it's probably original boards that were in there. But there was an opening cut or formed when they poured the concrete.
And the doorway out to the exterior from the basement, was that, and is that separately keyed?
Oh, yeah.
And in regard, are there any doorways, for instance, up to the main floor of the house from the basement?
There's only one set of stairs that goes up, but the deadbolt is on the first floor side. It's not an access for people to come up there because it's got a deadbolt. So if you had a tenant in there, they couldn't come up to the first floor.
Now, in regards to the kitchen cabinets in the basement, again, we'll go over the photos that had been previously submitted to the board. But was there, well, first of all, who do you believe built those cabinets?
Well, it was believed that the person that built the house was a cabinet maker. We found that on his death certificate. But the thing about the cabinets is they're unitized construction. They're not like what you see at Home Depot where there's boxes and you put them together like a puzzle and you put the counter on the top. These are all one custom made construction. So if you bought an oven, you would customize where that oven goes in, and no other oven fits. You pretty much have to alter the cabinets. It's not like pulling away. These were all one unit, one piece of plywood for a face, then there would be a frame built on it, and doors and so on. As you can see, there's a photograph of how it used to
And in regards to the kitchen setup itself, was there was there a wall oven? That was,
Yeah, the wall oven was dated around the 1960, and it was one of those custom setups that it's not like today where you can just slide one in. This was specifically made for this oven. The cooktop was 10 years newer, but those could be pulled in and out because they were kind of a drop in. To this day, you could probably drop one in and it wouldn't matter. But the oven would be a different story. That was custom made for that particular cabinet.
and you believe that the cabinets were custom built by, I believe it's Mr. Poach?
Yeah.
So it's only- And referring to Mr. Mitchell, item 19, attached to item 19, which was your sworn statement, there's a certificate of death for, is that for Mr. Pouch?
I believe so.
And then also attached to the to your affidavit is are some photos. Okay, and in the first photo, what do you see in that first photo?
Yeah, this photo is from the tenant side looking into, this is the garage door. In other words, you go through this door to go into the garage in the basement.
And this is the one that was this used exclusively by?
Can only be used by the person in the basement.
And the second photo?
Is the inside the garage area of the garage. If you went through that door from the apartment side into this would be the garage side.
And what does that show in terms of the how and when the door was originally framed?
Well, back then they just put 2x12s and boxed it in and poured right over the top of it. And like I said, it was poured all in one shot. And you could tell by the way how tight it fits against the plywood. There's no way that if somebody modified that the ply you could see in the corner, that there would be no way the cement would fit perfectly into the uneven joint.
So when do you believe that
This is
frame,
original.
so you believe the framing itself is original?
Oh, this is when it was first poured. The house is first poured.
And the next photo, third
It
photo,
shows the corner in detail why that if there was any modification to the framing or anything, you would see it wouldn't fit that well.
and the last photo,
It's the top of the header showing the steel reinforcement.
and then you have a picture of it has a garage door, and that, what is that showing?
That's the garage door that goes obviously into the garage.
So that's the outside door.
This is the outside door.
And then there's a picture outside of the on the outside of the house. What does that depict?
That is the private driveway, which has a walkway into the face of the house to the front door.
Now, when you say private driveway, what did the driveway serve? Who would use the driveway?
Only the people that are in that apartment. There's no other way. You'd have to go around the whole side of the house in order to go to the first floor. This wasn't designed. It was designed for the people down in the basement.
And does this photo show the exterior door?
It's off to the right. You can barely see it there, but I think we've got photos right show the front door.
So I'm referring to, photos that are marked item 22, but also exhibit 5. And I'm gonna have you, describe what this is, and I'll show it, hold it up for the board.
Yeah, this is the front door, and you can clearly see that the foundation is right up to the edge, up to the brick molding. You can see the brick molding needs to be all replaced.
And this is the exterior door?
That's the exterior door.
I wanna make sure all the board members see it. And the next photo, what is that?
Next photo is the preformed end of the foundation on the inside of the door.
And again, this is the exterior door?
That's the exterior door and the interior part of it. You can clearly see where they've taken the foundation and for a doorway.
And lastly,
this is the latch side, which clearly shows there's even a board inside the foundation for a latch, but you could clearly see the old foundation wall.
and again, just like the door in the garage was the frame for that exterior door put in at the time the original foundation was poured.
Right.
Okay, the record should just reflect, this is Attorney Capola, that I did individually show, the black and white photos, the 3 that comprise, exhibit 5 for this evening, or Attorney Griffith's item number 22 to each of the board members. Thank you.
Now, Mr. Mitchell, I'm gonna refer you to, paragraph 7 in your affidavit. Can you take a look at that? So, Mr. Mitchell, you included an attachment in regards to the US Government 2020 census,
Yes.
and why did you include that?
Well, because the US government recognizes that there is a apartment there. There is a photograph of the census envelope.
Now I'd like to refer the board to, its, package item 5-1B, item number 7. It's a series of photos. I believe the first one's labeled as basement plumbing 2.
Yeah.
5-1B.
It's up on the screen also. Should be.
Yes.
Okay.
It's in, because they were,
Number 6.
I'm sorry, Jennifer Capola for the record again. what you were provided for the order was the way they actually were filed with the court. So 6, 7, 9, and 10 were all grouped together. I believe what he's showing you is actually, is it record item number 7?
It is.
What's the cover that kind of thing?
It should start with record item number 6. 4 and 5 are the minutes and transcript, so it's item 7 within the packet that consists of 6, 7, 9, and 10.
Right, okay.
And they are up on the screen.
Thanks to Adam.
Thank you, Adam.
Thank you, Adam. So, do all the board members, have they found the photos? Or see them on the screen? Okay. So the first set of photos, Mr. Mitchell, can you just briefly explain what they show?
You can see there's a toilet to the right. So that's plumbed in, and you can also see inside the wall that there is a fixture that's sitting straight up out of the floor for a sink. And you can see that would be the drain for the sink, and you can also see the plumbing there for the hookup for the hot and cold water.
And the second photo, the one below,
Basically shows the main line coming for the second floor and the plumbing for the second floor,
and
or
that's
the first floor.
and that's separate.
That absolutely has to be separate.
And
The only thing that's common is the 4-inch main. And that is for the heavies, it's the vent that has to be separated. Where the air comes in, it has to have the air flow through it. It's okay to have the 4-inch main because it'll take the volume. But it's the venting that determines the first floor from the basement. And that's the important part. Very unique.
the second set of photos, they're labeled toilet and shower plumbing. The photo on the top, what does that show?
One shows the sink of the shower. It's a cement shower. And you can also see where the plumbing is coming up through the floor, the old lead and oak pipe. And it's the original, you can see the cement. It's kind of hard to see, but it's the wall was actually looked like it was put in when the cement went.
And also, I don't know, you might be able to can you see the view over here?
Yeah, that's the shower to the right, and then to the left is the plumbing coming up from the floor for the sink.
And then the third set of photos labeled bathroom plumbing.
Yeah, one of them is a, that right there is the sink trap, and then the Y coming out of the sink trap is the next photo down, and because it's got a clean out on it.
And that's the original plumbing,
Absolutely.
and that's coming out of the concrete.
Right.
And then on the next page, you have two photos. The next two photos are front shower and back of shower.
Right.
What does that show?
Well, in the old days, in the early 60s, probably not much any time before that, they used to pour the showers as one whole unit. And then they would eventually tile them, but they were all poured, the bases were all poured, which makes the plumbing pretty permanent.
Next, I'd like to refer Mr. Mitchell, you and also the board to package number 5-1C, item number 8, There's a series of photos.
It is a separate packet. You should have it. It was after the notice of filing. There was the notice of filing, then record item number 3, and then record item number 8. Somewhat small, yes, number 8 is what you're looking for. And again, we do have the original copy from the court, because it was difficult to get good copies
That's it
of
right
the
there.
photographs that are included. We do have them up on the screen as well, so if you'd like to look at any of the originals, please let me know and I can show you the court original, thank you.
So, Mr. Mitchell, on the first, there are two, there's a photo number 1 and photo number 2. What does photo number 1 show?
Photo number 1 is what we were referring to before about where the oven fits. This is actually where the oven slides in and the way it's wired up. So you can see that it's not anything conventional that you'd see today.
And why do you say that?
Well, because everything is unitized and they would be probably a lot, I guess unitized would be the best thing because you can move them around a little easier. This is pretty permanent.
And what is number 2 photo show?
Is the, shows the stove, top cook, and the sink, and the way the cabinets lay out.
And is the wall oven also?
It's to the extreme right.
And was that, again, you're talking about custom built in terms of the wall oven, does that show it built in?
Yeah, that's what the upper picture is. This oven actually slides in, and that's the MC that is connected to it.
And then photos number 3 and 4, what does number 3 show?
Number 3 is the outside of the cabinets, which just shows a face and old plywood painted doors. Second one shows the way the construction was made. Like I say, it wasn't boxed individually, it was made pieced together. Piece of plywood on one side, and then you divided it up by boards, and it was all one piece.
And you did some research back at, in terms of the style of cabinets, does for instance, photo number 3 reflect that style back at that time?
Yeah, that's the way they used to. 50s, early 60s.
And photos 5 and 6, what's photo 5 show?
This is the style of the cabinets. Actually, that's where the oven went in, and then the cabinet above it is what that is. The way it slid in.
Is that in 6 too?
Yeah. They're tough to look at. This is better. You can see in the previous photo, or the one that shows on picture number 2, you can see that there's a cabinet above, and that's essentially what is number 5. You can see a cabinet that's just open.
And then the next set of photos, I believe, are related to the cooktop, is that right?
Yes, the cooktop, this was made 1970, I think, with the serial number.
You did some research on that?
Yeah. Now the oven was 1960.
And that's on the last set of photos?
And we have the from GE where it came from. There's 2.
So, Mr. Mitchell, in regards to the point of all this with the plumbing and the kitchen, and the kitchen setup, it was there for, and used for, and continued to be used for a very long time, is that right?
Yes. I mean, the building inspector went through there and looked at it, and there was no modifications. This is period stuff, had not been changed.
In regards to the, in regards to the, rental of the basement, when you bought the property, from, the prior owners, they let you know the apartment,
Yeah, they were renting out, I'd rented it out for 2 years.
and then when did you stop, or why did you stop?
Well, there was some rumblings, zoning. When I started to being a contractor, I wanted to comply with the law. I knew that there had to be a separate service, separate gas, so I pulled permits to do that. And the question was asked, why are you pulling an $8,000 permit on electrical, which is a substantial amount? Because I planned on rewiring the whole house because it was old standard wire, gave me a chance while nobody was down there to separate everything was gutted, and it was a good time to put it up to code.
Do you remind us of the purchase date again? When you purchased
When
the
did you
house?
purchase the house?
Oh, it's 5-6 years ago?
2015.
Yeah,
You have 2 gas meters in the house?
no, I have one.
How's the furnace downstairs?
I have a wood stove and I have a air conditioning heating unit in the attic. That
So
services both.
nobody had a furnace downstairs?
I have a wood stove.
No, I mean the
Furnace.
people that lived there.
Oh, yeah, they had a boiler, and they had put in a brand new boiler, and get this. They put in a brand new boiler, never used it, and I found out why. All of the baseboards had been leaking so bad, the first 10 feet, all the way around the whole house had to be replaced, along with all the baseboards. That's why I had to put in a new heating system. And everything was rotted. Got all pictures of that if you wanna see it. That's why they didn't turn the, they condemned it and they put a new one in and they never turned it on. I bought it in September. So it was no, the guy turned it on, but he
So they had 2 boilers?
One.
For the house?
Yeah.
1 boiler?
one boiler.
So the people that lived downstairs didn't have heat?
They had they had a wood stove.
That wood stove?
They had a wood stove and they had a fireplace.
That was their form of heat for an apartment?
Well, there isn't a whole lot of heat needed apparently.
Well, I know, but.
How about water meters? Is there just one water meter?
There's
in the
just
house?
one water meter. And I have several renters in New Britain, and the way I do it, which is perfectly legal, I have 2 houses in New Britain, that I rent out rooms, and everybody shares the utilities. It's extremely inexpensive. In other words, if you have 3 tenants, which is allowed, you would divide up all the utilities. You get the bill, you divide by 3, and everybody finds that it's living very, very conservative. And
It's
you
not
only need one.
exclusive though, especially with water. You'd have to put a separate water meter at the entrance to each of those units.
No, they're bedrooms. The bedrooms is what's rented and the other areas are common. So, believe me, with the water bill and everything else, you'd be surprised when you divide it up by 3. If you had a bill that's $150, that's $50 a piece for heat, let's say, or electricity. It's very inexpensive that way. People find that I have never had a complaint because they see the bill. And I have high efficiency stuff anyway. I have all 96% efficient heaters. So, and 16 SEER air conditioners.
So before you bought the property, it was a 2-family house and people were living in it? It's 2 families?
Yeah, the apartment downstairs was completely set up. I threw out all the stuff.
Clarify, are there 2 driveways?
Yes,
So there's a separate garage for them, and
Yeah.
and the upper level is a separate garage for you.
and entrance, yeah,
2
So-
totally separate driveways.
absolutely.
Who were the families that were living in there between the time this person left and the time you bought it? Was there one family living there?
The Reagans,
No, I mean, the house was purchased in 2015, you said?
yeah,
Okay, so prior to 2015, was there two families living in there?
when I purchased it, they had gotten a divorce.
I'm
So-
asking you a question. Prior to 2015, was there two families living in the house? That's all I asked them.
No, sir, there was
Okay.
only
When
one
was-
person living in the
When
house.
was the last time there was two families living in the house?
I do not have an answer to that. But I do know that I looked up the records, and 6 months before I bought it, there was an ad in the paper for $1,200 for that apartment. That was just Googled.
But there's no record of how many families lived in there prior to when you bought it.
Other than the fact that there was a 2-bedroom and everything was all set up down there.
I know, as I told you before, house I lived in had a walkout basement, it had a separate garage around the back, it had a garage in the front of the house, it had a kitchen downstairs that would probably make the kitchen upstairs jealous. Okay, it had a shower that was 4 feet by 6 feet, it had a kitchen, it had its own heat downstairs, and it was a single family house.
From what I understand, as long as that the people did not abandon that situation, and that let's say they pulled a permit and said it was a single family, that would be abandoning the use. I think the use was being used, if they used it or not, I think as long as they kept that as the use of that basement.
Well, I'm trying to figure out how many years this thing was being used as a single family house, because it sounds like there was an apartment downstairs. It could have been son, could have been son-in-law, could have been a college person renting it, whatever, okay? There was an apartment downstairs, and then all of a sudden, there was a fire at the house, and then it
The
says.
Sears lived there.
Yeah, and then it said after 1981 or 1983, the person lived there till 1983. And what happened in the 1990s? And between 1990 and 2015, in the last 25 years, what happened?
I
How many
believe it's,
families lived there?
well, I can't answer that, but if you had an income that the person before was getting, you think you would abandon that?
If I had an income that the person before was getting,
Right,
well, if I bought the house and I bought it like I bought my house and I have a basement down in the kitchen that I use for whatever, parties, for sauce, for making whatever. Yeah, I mean, I could, in my house, I could actually live four people downstairs and 4 people upstairs. You know, I mean, there wouldn't be no problem, because in the house,
did your house start out that way?
yes,
It was a 2-family?
no, it was plumbed downstairs for a second bathroom, it was plumbed for a second kitchen downstairs, it was plumbed for a stall shower downstairs, it was all built that way by the
The
builder.
year the house was?
The house was built in 1972. It's a single family house, and it's built in a neighborhood that's a single family neighborhood.
I guess,
Yeah, well, I think that's apples and oranges.
well, no, I'm
Well, I don't know.
What you're saying is you went through length to describe the original foundation, the original this, original that. And in my head, I'm wondering, well, what's different from a fully
When it was
finished
built.
basement versus,
No, when it was built
Two-family.
is the important fact here.
but why
because-
wouldn't that be a
Because zoning
finished
allowed it
basement?
at that time, zoning in 72 did not allow it.
Yes, they did.
I believe it was 60s that they changed the zoning.
No, zoning in 72 allowed it because it was a single family house. If I want to put a kitchen in downstairs in a single family house, I'm allowed to do it.
Yeah, but the zoning did not allow, after 1962, that there could be up to 2 families in a dwelling.
Oh, absolutely
Because the
not.
farm zone, yeah, that's what we're talking about.
That's what-
that's
The
not-
farm zone, yeah, the farm zone, it changed in 1962.
I mean, as long as your family was all one, that was fine. But this was 2 separate dwellings.
Yeah,
And
but-
the definition, believe me, the
Yeah.
definition isn't much different. It's just the time that zoning allowed it.
We're going back to the zoning was changed. Okay, I understand that part of it. Okay, but then, for 25 years, we don't have any record of what was going on there. 1990
previous leases or bank records of
2015.
security deposits being held or anything of that sort?
Well, look, they were going through a bad divorce, so the person, when I bought it, they nearly lost it. Not to mention that,
When you rented it for you said you rented it for 2
oh
years.
yeah, I rented it for 2 years.
So where are those, where's that lease or those the bank account with the security deposit being held in escrow?
Oh, I have that.
Why isn't that in evidence?
Why isn't that here?
Well, I didn't
That's like
think
the
I
most
needed,
proof
I didn't
you
think I
need.
needed that, but anyway, that, the guy's name is Jim Kern, I can give you his phone number, you can talk to him. I have no problem with that. But, the whole point here is in answering his question, his was 1972, this is 1958. So zoning was different at the time and they looked at things differently. And I don't think that it was abandoned, and you have to, the way I understand it, you'd have to pull a permit and alter what is going on down there. Nothing has been changed. That's the key here. If there had been modifications down there and things were done, then yeah, there'd been some modification, but nothing has been done. That's why it was very important that I pulled the permits.
And the clarification, the part that's confusing to me is that the house was built maybe as a two-family. Okay, the laws changed with the zoning, and you said nothing was done.
Well,
If you bought the house and you had a kitchen downstairs and you had a bathroom downstairs and you had a large family, why would you change it anyway?
here's the key. When you said the zoning changed,
Right.
we have proof that they kept using it beyond that point. That's the key. We didn't, the person did not abandon it, even though there was a fire, which was the question before. They did not abandon it, they kept using it for another 10 years beyond that, or 20 years.
And there also was evidence, there's also evidence in the record, I believe when your zoning enforcement officer got involved and told the prior owner, we were talking about that you can't be using it as an apartment. So that right there was a recognition that it had been used at that point. And in addition to that, there is some recognition in the tax records themselves that show that there is a apartment or in-law apartment over time. So there's a recognition by the town that it existed there.
In your
We have
stuff,
that in our packet.
There is, it's, the taxes are in.
item number 20 in this packet, can you explain that?
Item number 20
I
is,
think that is the taxes.
well, that's the old, I believe that's the tax assessor.
On page 2, there's a thing checked off as one family.
Right, where's this now?
The second page of item 20.
Okay. Yeah, that's the original,
So it says one family is checked off.
right? And that's what the original, is that what the original owners?
Yeah, I assume,
Yeah, that's the original owners.
so why
For,
is,
for tax, and that tax card, that's how it's shown, but we know, starting in 1960, that the Sears, used it that way. And we also know that Mr. Couch custom built the cabins for the basement. It was rented out from that
so
time.
this is from 1956, then, correct?
Correct. That was when the house was built.
As a one family, according to this.
The other side.
Right.
May I ask a question? I'm sorry. Again, I think you asked about page 2 of item number 20.
Yes.
David, could you look at it? Because it has Raymond and Bernadette Sear on it.
Yes,
So they were not the original.
correct. No, pouches were.
Okay, yeah.
The pouches were the original. They owned it, they built it and owned it for a couple of years, and then they sold it to the Sears.
So, is this going back to the time, I just wanna ask, Jerry Griffin, is this going back to the time period, remember when years ago, the owners would have to come in and attest to the record? This goes that far back.
Are you talking about with the assessor? Oh, I don't know what,
remember years ago,
yeah, but
it
I,
was part of the process is.
well, I don't know if there, if that's what was done in Berlin at that time.
Never, again, we hadn't seen that particular item before.
Mhm.
So, the Sears neighbor was on top, so this is.
So assume in the old days when this was done, people came in and there was just one card for the property and they added the Sears name to it. So this was the original card.
I believe that was the first card.
1960.
But this card was made in 56, I assume.
And then it
Yeah,
shows
that
it
was
as
the
one
first thing.
family, then it shows it as one family. 1965, it shows it as one family.
I don't think they determined single family or two family because it was farm zone.
Yeah, I remember asking this question in the first hearing about what, I think I asked it to Thomas, who was here, backing up his staff comments, and it had something to do with, it's in the minutes that we approved tonight, it had something to do with the taxation is not relative necessarily to the use under the zoning law. So that, I think we talked about this, I think Landon was bringing this up and Nelson, we talked about this card, and that the assertion here of the appellant is that the tax card really doesn't have a relation to the use, or it doesn't have any relation to the abandonment, if any, of the use. So I'm not sure, I mean, what is the purpose of including this in evidence if it doesn't support the two-family use?
Well, I think it
Shows it was finished.
yeah, and I believe it also reflects that that there was originally a basement garage that was included in that.
Okay, so I think I would request that we come back to the purpose. I think the end purpose is for the board to consider the proposed finding of fact as revised. And if the board agrees with the proposed findings of facts, that this fact pattern as laid out would show that there was no abandonment as originally asserted by the town planner in the first hearing, and that there was a non-conforming use before the 1962 change in the ordinance. So can we get back to the list here of 7 and talk about what proves each point? I think we've thoroughly gone on as number 1. I think you talked about the evidence that supports number 1, number 2, number 3, number 4. Let's move on to 5, 6, and 7.
So number 5, I would refer the board to, in particular, the statement of facts by Kevin Sear.
Okay, so we got an affidavit from him. That takes us to 1981. Number 6 then makes a statement that covers the period 60 to the present. And we know we're covered from 60 to 81. How about 81 to the present? That gets to the questions that we just stopped.
Right, and I would refer again and again, I know that the tax records do not reflect or not necessarily mean that it was used that way, but there was an indication in the tax records that there was apartment use there. And in addition to that, there is a recognition back with the prior owner. The town knew that it was being used as a two-family because there's a communication when it went on the market. They must have it went on the market as a two-family with an apartment in the basement. And there isn't anything in the records that show that it was abandoned in any way.
Then it was kept up.
Well, I think what we're arguing, or what we're seeking is the validity of or the strength of the evidence that supports that 81 to present time period. I feel like the tax records and that the town knew isn't the strongest evidence. I think we said, well, maybe a lease or bank record, or, you know, I mean, you wouldn't have that for prior owners. But there's some question in my mind about the strength of the evidence for number 6. Let's move on to number 7. You've got a census for 2020, but then you make a statement, Attorney Griffith, that on your summary, that the census recognizes the house as a 2-family dwelling. Your statement was reflects the lengthy time that the address has been used as a 2-family dwelling. So that was one of my questions: is how you get from a single census form to the lengthy time. I mean, maybe you can get to the last census to 2010, but so I'm still questioning the period 81. And if I'm charitable, to give you from 81 to 2010.
Well, the prior owners became the owners, the Reagans, in 1991, and those are reflected in the tax records. And they listed the property as having an apartment, and I think it can be inferred from that.
Well, the other thing that I have to, maybe a choice of words.
Mhm.
When you say 2-family and you say apartment, are we saying the same thing?
I see here it says in-law apartment
Is
on
it
one
the
of
same
these
thing?
cards.
Because one says apartment, in-law apartment. My son's got an apartment downstairs, he's living downstairs, he's going to college, he's got the same address I do, he gets a census form, same way I do. But when you say 2-family, I understand 2-family, but when you say 2-family or you say apartment, is there any kind of a differentiation between those two terms? Because we gotta keep them apart.
Keep what apart?
I can't say it's a 2-family. I mean, you said it's an apartment, now you're saying it's a
Well,
2-family.
an in-law apartment can be a term of art.
But this is 2-family, the census form says apartment.
Yes.
It doesn't say a second family. You know, I mean, it says apartment now, so I'm a little bit confused because you're using the word family, 2-family, and you're using the word apartment, and you use them interchangeably, and I don't know if that's correct. That's all I'm asking.
Yeah, I think zoning has a big part of that, of what they would call, because you can have an apartment and be a second family or multiple family apartment, okay? And so it would be a zoning definition.
That's what's confusing me a little bit, I
Well,
guess.
I understand where you're coming from, but at the same time, doesn't mean, a 2-family doesn't necessarily mean that it's completely, the buildings are completely apart from each other. As opposed to, you know, a 2-family with like a New Britain, or it's 3-family. They're just, each floor is a different apartment. That's still considered a 3-family.
Coming back to there's I'm gonna say a 10-year time period in between 1981 and 1991 when the Reagans, the previous owners, the Mitchells bought it. There isn't any evidence, what I'm gonna say is there's no evidence that it was abandoned. And what I mean by abandoned is, that the ingress and egress was blocked off, that there was, disconnecting the plumbing. There doesn't seem to be, there isn't any evidence to that effect, in regards to this.
Well, if they didn't have any money to do anything, it wouldn't be any effort. They were in,
But that
they
would
got
be.
divorced. They
But
probably didn't have
but the point is, they would have to show an intention to abandon the use, and there isn't anything showing that abandonment. As a matter of fact, in
Well,
regard.
isn't the intention to abandon the use the fact that they didn't rent it for 15 years?
Oh, I think they have, no question. When I took
What
it
happened
over,
between 1990 and 2015?
I don't have the bank record.
That's what I'm trying to figure out.
1990 was
I'm going back
Reagan's
to the
owned
same
it.
question I had before. What happened for 25 years?
Well, the Reagans owned it and rented it out.
They rented it out for 25 years?
They only owned it for 20, I owned it for 5.
Those are the 25 years.
You owned it
5 years.
for 19, you owned it 2015.
2015.
2015,
And the prior owners owned it from 1991 until 2015.
so that's 24 years.
Right.
And they rented it out for 24 years.
Well, they didn't, they listed it as a place that had a basement apartment to rent. Yes, do we have the actual leases? We don't have that, but it was listed that way, and that's when the town first got involved and said, you can't do that.
Only when I got it.
Perhaps it would be helpful for the board to come back to Attorney Coppola's letter to us on page 4, and where she's quoting the Cumberland Farms case versus the town of Westbrook, and where she's quoting the abandonment definition, the bottom of page 4. So I think the relevant one here, the sentence here is, to establish abandonment, the intention on the part of the owner must be to relinquish permanently the non-conforming use. And it's not necessarily that the intent to abandon is not enough. So I think that's where the Attorney Griffith was saying that there was no clear evidence that they were stopping the use of that first, or the basement, by blocking the door, rebuilding around the garage door, that kind of a thing. So, because to me, the crux of this case is whether, for us to consider, is whether or not the original staff comments from Mardik, and I misquoted him as Thomas before, Mardik wrote that they came to a conclusion that upon the rebuild in 70 after the fire, that the owner abandoned the non-conforming use. And I think the judge here is saying that that's not the definition of abandonment. And so if we were to find any problem with our original decision, it would be that we agreed with the staff comment that the non-conforming use was abandoned.
But then we got a letter from Sear that says it was not abandoned.
Well, I mean, we're talking about the entire period. Sear is a very small piece of that period. That's why I was focusing on the weak evidence part of the use.
Right.
From 81 on. I'm good with Sear's affidavit and all that, but so to me, if we're gonna say that we did anything right or wrong, it has to focus on, because we just agreed with the staff comment that we came to the same conclusion that the staff had, and we said that there's not enough evidence for us to overturn or to reverse the order. I take issue with the judge saying that we didn't do our job and say that there's a statement of finding of fact, because in our decision, we said that we basically didn't find evidence to overturn the order, which was clearly laid out in the staff comments, but maybe we should have just mentioned that. So to us, I think we need to say, was the original order valid? And if you go through the line items here on record item number 3 is all the prior material from the staff in our prior hearing. Where basically Mardik wrote an essay about why he came to his conclusion. Well, I should credit Maureen too, because Maureen, they worked on it together. So they wrote down all their background on this. And so where I marked off is where they said that non-conformity would have been abandoned when the house was rebuilt as a single family with no fixtures in the basement. That's a separate issue with the town. There's evidence, there's conflicting evidence in the record from the town and the inspection, multiple inspections, not recognizing any fixtures down there. So it's fine that we focused a lot of time on the actual pictures and the evidence that stuff existed. But I think, to me, it comes down to the decision on whether they abandon it or not.
Those pictures, are they current? Have we looked at?
Yes. And I'm gonna come back, I don't mean to belabor the point,
6 months.
but I believe that Mr. Sear's statement basically overcomes any thought that there was an abandonment when the fire occurred. Because he said we rebuilt the house and we continued the use.
So he rebuilt all that downstairs kitchen, everything?
No, it was original. It didn't burn there. It burned in the upstairs first floor. It
Right.
didn't affect the second or the basement.
I would, by the way, I would argue, let's just assume that happened. We don't really know.
Well, it's
Again,
fixtures
Fixers,
anyway, you ain't gonna affect
but if you reconnected everything and continued the use, the renting, then you haven't abandoned it. It certainly doesn't show any intent to abandon it, show the opposite. The intent was to continue it.
I'm looking at a field card here from when the Reagans owned it. And it's listed several different ways, in-law apartment and walkout basement. And over here it says basement, rec room finished. And then on the building sub area where it's saying different square footage, doesn't even list the basement as square footage, it just lists as living
It
area.
doesn't count. On a house, it doesn't count. Only the first floor counts in square footage in a house. Basements do not count.
Well, this is for taxation.
Yeah, that's what I'm talking about.
So,
If you have a basement, does not count for square footage in a house, even though it's finished. All they say it's finished. That's it, period.
I agree with that.
Well, that's a fact. All they're gonna say is it's finished. That house is a 1,600 square foot house, and the basement is nearly 1,200. So the house would be 2,000 something square foot, and it's listed as 1,600.
The gross area is listed as 1536 for the
Right.
base basement, where the living area is listed as 1642 for the first floor.
Right,
And it
that's it.
says, single family with apartment, rec room, finished basement, quality 3. And this is when the
Mr.
Reagans
Ferraro
owned
went
it.
around about that. You look at all of records, it'll just show the first floor.
Yeah, and it says also on the one with the, right here with you guys, Liam and Cynthia here, it says on this card, single family with apartment.
Notice the square footage.
In-law apartment and walkout basement. And this is the verbiage on the card.
Right, like I said, they do not count a basement for, even it's a walkout. Basements do not count in the square footage of a house
For tax purposes.
for tax purposes.
In-law apartments, count.
If it's on, let's say on a multiple floor, yeah, but if it's a basement, no. Don't ask me why, I don't make the
I've been
rules.
taxed on a furnished basement in this town.
Yeah, but they
Finished
list it as a furnished basement, and then you have the first and second floor, or whatever you have, as the square footage. They just list it as a finished basement and they tax it accordingly.
They listed
I
it
think,
as
I
by
think,
square
I think
footage.
they use that property as an apartment. And they rented it, they used it as an apartment, they rented it, I had a neighbor who, mother-in-law moved in and they made the garage into an apartment for the mother-in-law.
Oh, mother-in-law apartment's a whole different zoning.
But I understand, but it was an apartment. Okay, and, the garage and the area that was hers was locked away from the rest of the house and so on and so forth, but I guess what I'm saying is that going back to two-family versus apartment. They don't have 2 meters, they don't have 2 gas meters, they don't have 2 water meters, they don't have, 2 of everything. There's only 1 electric meter in that house, it's a single-family neighborhood. It's a development where I used to live. And I guess what I'm saying over here is this is a single-family area. And, when you go for 2 electric meters, you're looking at 2 family. When you go for 2 gas meters, you're looking at 2 family. But if you have just an apartment for, an in-law apartment or an apartment for a kid or whatever, it's not a 2 family, it's a 1 family
I don't know if
with
you're
an
talking
apartment.
about under today's zoning rules, et cetera, but again, we're talking about something.
But it must have been that way then, because if it wasn't that way, why didn't they put in 2 meters? The power company would put in 2 meters for free.
The one thing I do know about being in the rental business for 35 years is whatever's in the lease and what's agreed upon by the tenants. You don't have to, I'll give you an example. Right now, people are going back to 3-family houses. They're going back to a single meter. And you know why they're doing that? They want to take advantage of solar. So they're taking out all the meters and they're putting it in and they're dividing it up because the bill is so low. That's what's going on right now. But my point is, you don't have to have multiple meters. It was probably in the 80s that they started changing the meters. And I happen to know for a fact because I was the guy that had the law changed in the state of Connecticut. My industrial park, when I went in there, I went to battle with the CLNP at the time about meters. I wanted to put in individual meters. They didn't want me to. And we went to battle about it, just like I'm doing right here, okay, very respectfully. And they allowed me, and I had the president of CLNP write an apology letter because I lost all my tenants because of the battle. But my point is, that's when they said that tenants have to have a change of a meter or have different meters. Up until then, they had 1 meter for a whole apartment. It's just very recent, I'd say in the 80s, that they changed it. So meters aren't really important. It's what's in the lease and what is agreed upon by the people that are
I
renting.
never saw a piece of paper that said 2-family. I always saw a piece of paper in the town record that said single-family apartment. I never saw anything that said 2-family. That's the point I'm trying to make.
The lease.
Then
That's why when you
what's the
take
difference
definition of
between an
family
apartment or a
There's
2-family?
a little bit of a disconnect in my mind.
I know that, and I know that you had raised that point before, but, and again, my response to that is that even though it's not in the paper, if it has been continuously used, and it was used prior to the zoning change, the fact that there isn't a piece of paper that you're looking for doesn't change the fact that there is a legal non-conforming use here.
Apartment and a, doesn't change, just like in New Britain. They're multiple family, but they're called apartments. This is a 3-family house or 3 apartments. I fail to see any difference between the two.
Well, the way I'm interpreting it is that the ordinance is written as a single family and other than single family. So if it's not operating as a single family, doesn't matter whether it's an apartment, in-law, you call it a 2-family, whatever it is, it's not a single family dwelling. And the argument on the part of the appellant is that they have a non-conforming use, they are grandfathered in before 1962, and they never abandoned the other than single family use of the property. And so again, the germane issue is whether or not, if we can stipulate that it's a valid non-conforming property, that's like 1, 2, 3, and 1, 2, 3, 4. Then 5, 6, 7 gets to the issue of abandonment after the 1962 ordinance change. So if we stipulate that it's not conforming, the only remaining issue is whether it was abandoned or not. The use of it was abandoned.
And just to, if I can, Jennifer Capola, counsel to the board, again, I'm counsel to the board. I'm troubled by something because I was looking through, I don't recall, I'm hoping that Attorney Griffith can help me. I don't recall there being testimony that your clients, that they rented this apartment from the Regans.
They didn't rent it from the Regans.
No, we bought it from the Regans.
They bought it from.
Because he testified, and he testified twice, and I think it was actually Ms. Mazzata questioned it a second time. You twice testified, and
I rented it for 2 years. The first
Oh,
2 years that I owned the house, I
You
rented
leased
it.
it.
you misspoke. It wasn't from the Regans.
No, it was when I owned it.
I think he meant
That's
rent
all.
as in,
Because
he
she
let-
asked you, I think it was Ms. Mazzata asked you, do you have a lease from them?
I didn't mean from the Reagans, maybe I misspoke, any leases, like
Yeah,
you said
I
you
have
rented it
one
for 2
thought.
years.
Sure,
So
I have.
where's that lease and where's that bank statement with the security deposit being held?
I have a lease that I drew up with Jim Curran. Like I say, I can give you his phone number. You talk to
So
him.
why isn't that
He was
in this
disappointed that I had to remove him. Pardon me?
I mean, I guess I don't know why it's not in here with all this.
Well, I didn't think it was, the whole thing about this was the non-conforming, that the use from 1960 and on was the big issue. Believe me, I have pictures of the house when I first bought it that showed couches and everything in the basement. You know, if I thought that was relative, I could get it. You know, I got leases. Like I said, I rented it for 2 years. I can get a statement from the guy that lived there for 2 years, we're still friends. You know, he's disabled, but, and he still rents a trailer at my place, so. But the point here is that we did not, the use was never abandoned. And that's what the court, I thought, was saying. So the issue was about the burning and that the use was continuing past that because there was permits pulled. Well, guess what? It was all taken care of right up into right up until Reagan. So that was what we were hoping that would be sufficient. If you want more proof, I can get you more proof, but I think that this is just going, I think that nobody is trying to pull the wool over you. You know, you guys can take me to court if I'm lying to you, but I got no reason to lie to you. What I've said and here is all true. And like I say, I mean, I could even get the guy on the phone, he's probably up, you know.
Just before we go any further, again, Jennifer Capola for the record, you haven't heard from Ms. Tuesday. I think at this point, I think that you need to do that. I think she needs to weigh in on some of these things because she.
Thank you. I'm gonna just, because this was the most recent part of the discussion, just go back to him having rented the apartment. That was the thing that was called to the town's attention that caused the order, the cease and desist order that then did the. So he rented it after he bought it in, he rented it, he bought it in 2015, 16, the end of 2015, I believe. And then rented it. The rental was called to our attention. We researched the property and the order was issued on the fact that he rented it, whether it was for a day or a year or 2 years. Once we found out, we sent out the order that it was illegal and that's what's being appealed. So that might clarify that time period of him renting it.
Question, there was permits pulled first, then I got the cease and desist. That's a very important point, because the permits were to separate the utilities as for a 2-family apartment. That's what caused the town to give me the cease and desist. So I just want to get the order in that correct. Okay.
You're gonna hear a lot of repetitive information and I tried to re-summarize instead of reiterate all the things you had in the packet. And in my comments here, I'm pulling out the highlights because you do have them, you've seen them, you were actually given the same documents a bunch of times. So I'm referring to documents that I believe were labeled by Attorney Capola as like ROR 3A3 in the package that would have been the
Three?
third set of documents.
Yeah. Item number 3.
So just so you can find which set of documents I'm flipping through with comments,
Yeah.
so, I mean, you know,
Yeah.
they start with my staff comments from 2019. They give the history of the property, what I found, what caused me to determine the conclusion I had that it was not a legal apartment for rental and that, and they got the cease and desist order and the background, the investigation with the assessor's office which goes to the background and then the supporting documents of the building permit record, et cetera. And then you have the rest of the enforcement file. I'll remind you that enforcement files, when we get appealed, we have to include everything we found to you, and that's why they end up being so large as opposed to variances or whatever, your other charges where we give you a summary. So what I'm gonna try to do now is give you a summary of those key points, and then I'm gonna follow that with responses to comments that have already been made. So I might go back to some of them, but I wanna stay on task and not miss things. So like I said, go back to that record. And there's several layers of issues that I wanna call to your attention, and it's not. So even if you disagree on one point, that you may agree on another point. And I want to make that clear that the record has to be looked at so that I believe my order should be upheld. We'll just start with that. The 2015 property sale listing showed that it was a single family with apartment. Again, that was a real estate listing. I a little opinion here, but I think we've all watched HGTV, and anything that has potential for income, can be construed by someone who hasn't done their due diligence as being allowed. So, as an apartment or whatever. And so that was, and then the record was researched because we found that property for sale listing was called to our attention. And the record was researched, and a courtesy letter was sent to the owner and the real estate agent. And you can start with ROR 3A3. Real estate agent that no COs or permits were found for that space, that basement space, to be authorized as an apartment. ROR 3B21. No claim at that time was made that to the town that the ZEO finding or letter was inaccurate. Now that would have been a time to appeal a finding of the town. That did not happen. And that letter was then put into both the zoning file and the building department file. I'll let you know that our offices, both the building department and the zoning office, spend a considerable amount of time providing due diligence information to banks, to buyers, to real estate agents, people who've done their due diligence, that has them find those records. So they would come, they would have looked at the building permit file and found that letter that was to the owners that they should not be listing them having an apartment because the apartment was not found to be authorized by the town. If you then go to ROR 3A4, after the Mitchells purchased the property, building permits were obtained, and they were noted that they were for interior renovation of single-family residence, and included an electrical permit indicating the same. Single family. We knew there was an issue with an apartment. We issued permits for a single family.
False.
My recollection is that he inquired on permits for an apartment, and it was discussed that any apartment was not authorized, and the permits were appropriately noted for single family to limit any future confusion. It is my position that if the zoning determination at that time was determined to be incorrect by the owner, the determination should have been appealed at that time. When you make a determination, when the zoning officer makes a determination, there's an appeal period that follows it. So again, another time period that was reiterated. Then we'll go back to the permit history as detailed in ROR 3A3 and 3A4, with key points being in 1954 there was a building permit application for a 6-room house. in 1954, the building permit with the data that says number of housekeeping units, 1. CO issued in 1954. It later indicated it was issued in error. No subsequent CO document was found, which could lead one to believe that the error was rectified and the CO found accurate after a new building permit was issued in 1956 as reissuance of the previous permit. Again, housekeeping units was 1. Remember then that Attorney Griffith stated that the ordinance changed in 1962. In 1968, permits were to demolish the dwelling and a permit to build a one-story frame dwelling. There was no indication that the basement was habitable space. That's ROR 3B11. Related to that permit for the installation was a permit for the installation, alteration, or repair of a private sewage disposal system, which indicates 1 family, 7 rooms, 3 bedrooms, 1 bath, 1 shower, 1 lavatory, and then it says, this is ROR 3B-14. Basement fixtures only with special permission, and it's left blank. There's no notation. It's left blank, no basement fixtures. The related certificate of occupancy, use, and compliance approved as a single-family dwelling in 1970, ROR 3B17. So again, now we're after that, we're after we become a residential zone from the farm zone, and we're still talking about a single-family dwelling, not a 2-family dwelling. Therefore, I'm gonna repeat myself. Therefore, I maintain that given the farm zone regulations allowed a farm dwelling to be a 2-family, that does not preclude the need to acknowledge and get permits for the installation of amenities that would make it so. And submitted and issued building, zoning, and septic paperwork reflect that the finished rooms on the first floor, 3-bedroom, bath, kitchen, dining room, and single-room basement. Common sense says that any basement garage may be accessed by an interior door from the basement into the garage. So I don't understand where the argument that there was a door from the basement into the garage makes any, like, I don't understand how that supports an apartment in the garage, in the basement. There, you would have a basement door from your basement into your basement garage, you know, as he indicated was built. The applications to rebuild the house after demolition does not reflect the second unit or dwelling in the basement. Then I'll go on to the assessor's cards to describe those. Assessor's cards are a tax function. The acknowledgement that amenities were in place for an in-law with no related permits shows what was seen on site by an assessment official, so that the value and tax can appropriately reflect the finishes on the property. It does not show necessarily an approval of those amenities or how it is used if approval is necessary. The 1966 card, ROR 3C 4 and 5. 2-sided. Cards are 2-sided, and I realize some of them are pretty difficult to read and some of them are reduced because they're larger than an 8.5 by 11 sheet, but they're just an odd size. So,
Just again, for the record, we do have the original copy that we submitted to the court, so if there's any particular item, any page you wanna look at, the copy that was submitted to the court would be a better copy. So don't hesitate to ask for that.
the 1966 card, occupancy single, basement, 1 room, rough toilet. 1976 card, it's noted as the R43 zone, and I will repeat that as Commissioner Zelik pointed out, the cards are established in 10-year periods and then up until the time we went totally electronic on these, any change, it was a single card at one time, at the time it was established to start that 10 years. And then any changes to that card are done in hand on most of these permits or further notations made. I will note that ROR 3C8 has my note on it, which I added and put the date on it. Adam's highlighting it, and I'm sorry, I have to lean over to look at it. 6/8/2018, I had a conversation with the assessor that their kitchen was in the basement, asking for an explanation of this card, and he said the notation of apartment, which would have been done and added to the value, which there was no notation of that. That is, so the value would have been added for the apartment.
Kabusi?
That one,
Yeah,
Sear then
he
Kabusi,
used that basement kitchen to make sauce. I know that guy, he passed away several years ago.
I know Kabuzi real well too.
so,
Somebody put something down there.
Yeah, that's what he did.
so again, noted as an R43 zone, occupancy 1 family, indicates the basement has finished rooms and kitchen. As was mentioned earlier by a member of the board, there are a number of homes in town that have several separate kitchens in the basement or second kitchens, known by several different colloquial names, such as a canning kitchen. And it does not mean it's allowed to be used or exist or authorized as an apartment or a second dwelling unit. The 1986 card, the dwelling data, the number of living units, 1, ROR 3C 12 and 13. I'm sorry, I'm adding these after the fact. The basement is not noted with finished living area, no extra units are noted, but the basement bathroom is noted. And the 1996 cards, 1 living unit, 1, or living units, 1. And then there was a note, in-law apartment in walkout basement. I will further provide you with additional information at this point that by this time, the Reagans owned the property, and I had a conversation with Miss Kim Reagan this week. She was the owner, the wife that owned the property, and I summarized the conversation that I had with her on the 22nd with a follow-up conversation today, and then sent her an email of that summary for her to confirm the conversation because of timing and finding her, etc. We did not. This confirms that she agrees. I think we probably need to label it as exhibit 5, right? I think it's exhibit 6 or exhibit 6, I'm sorry. Oh yeah, the pictures are 5.
If I might say, I am surprised that this wasn't provided to us until right now.
It was finished today when I got confirmation from her.
As was my proposed finding of fact and my revised finding and my photograph, and I share that with Attorney DePaul, so I think it's.
Well, Attorney, just for the record, David, I did not see this.
Can I ask the overwhelming question as a citizen of this town after being here for 35 years? And anybody that knows me down at 44 Washington Avenue, the things that I've gone through to try to be, to help small business and everything else. What are we accomplishing here in all these details? Because first of all, I heard that the assessor cards, first of all, weren't supposed to be a part of the, the proof, so to speak. But yet we proved that it was built for an apartment. It was used as an apartment. through the time, and it wasn't abandoned. Even if Mrs. Reagan didn't use it, it still wasn't abandoned. But my point is, what are we accomplishing here? What is the rule of what the law says that we're doing something wrong?
If I may, Sharon, the applicant was afforded the opportunity to speak without me commenting on their testimony and me, taking detailed notes and commenting, and I would like to be able to support and finish the information that I found. Again, going back to, if I may, continue. I'll just start with her confirmation. Hi, Maureen, that is all correct, with the exception that we did replace the countertop in the basement. If you need anything else or I can help, or if you think anything else pertaining to that property, I will send you that information for your files. Okay, so then my email to her stating, as discussed on the phone, please find the summary I have prepared based on the conversation we had regarding the circumstance and use of the property at 1005 Kensington Road while you lived there. Please confirm that it is accurate and or note any corrections. Thank you for the time. I appreciate your responses. Again, you can take her response and her information provided for that time period that she owned the house from 1991 to 2015, 24 years, as what she provided me. I was searching facts or searching information. Kim and Peter Reagan owned the property at 1005 Kensington Road from 1991 to 2015. When they moved in, the finished basement had attributes of a walkout apartment with a galley-style kitchen, full shower bath, dining area with fireplace and living room. The kitchen had a stovetop and wall oven and also had a separate washer-dryer hookup. They installed new carpeting and possibly replaced the countertop. She then said she did replace the countertop. She stated she used the extra basement oven as needed for holidays, etc. She stated they did not rent it out, but the brother-in-law lived with them downstairs for 8 years. He contributed to the household and utilities. There were no separate utilities. There was no separate mailbox or address. They never opted to hook to town sewer. And she also noted that there was a well on the property, but the pump was taken out prior to them living there, so it was abandoned. She was just giving me information about the property, so some of this may not, be including that. And then in the subsequent clarification and details provided today, she noted the basement was used as a family playroom space after her brother-in-law moved out, and noted that the main level garage must have been added as the kitchen window looked out into the garage. She surmised by that, surmising that the basement garage, was part of the single family dwelling. Again, I just wanted to go back to that. She indicated that they never intended to use the basement space as a rental apartment. Her brother-in-law did occupy it for approximately 8 years of the 24 that they owned the property, but he did not pay rent or have separate address or utilities. He contributed to the household bills, and over the years it was used as playroom space and as extra cooking space. Voting records were available only back to 2000, and they indicate that the Reagans were the only registered registered to vote, and that included her husband, and her brother-in-law. I have those records. They should be part of this. Kim Reagan, Peter Reagan, Andrew Reagan, and Patrick Reagan. I don't even know if I'm pronouncing the name right. I hope I am for their sake. Those names correctly.
So Jess, this is Jennifer Capula for the record. This email exchange again, I believe is exhibit number 6.
Yes, they labeled it as such.
And so Ms. Tuesday, you're offering that's their voter registration records?
They're the registration records that the registrar of voter was able to provide. They said they had only back to 2000.
Isn't that where the census things come from?
I am
I think that's
unaware.
Tie in with that. Census.
Not everyone's registered to vote. The census is tied directly to the house.
Probably post office.
Post office.
Can I,
Should you just give council that one? Okay.
Sure.
And who's in?
Do we know who Peter, Andrew, and Patrick were?
Peter and Kim were the owners. And she acknowledged her brother-in-law lives there.
So the other two was
Okay, so, if I may be heard, again, I could say that did not know about this email exchange. I would ask the board to not consider this by reason of the fact that it was not provided to us in a timely fashion. Number two, it's not sworn, okay? It's not a sworn statement. So, again, I'm objecting to it. And then there are voting records. They look like computer printouts to me. I don't know where they came from. And I don't know what the purpose is for purposes of what we're showing here.
If I may, I was trying to get more information on the property to see whether there was information that showed differently than, or the same, differently, whatever, information, fact finding. Is there another name?
To answer his question though,
Let's not talk about it, because it becomes a problem, like if we're gonna need a transcript, so just finish your thought. Thank you.
And again, the email was late this afternoon. This seemed the fastest way. I don't know procedurally I'm not a lawyer. If there's a procedural issue, I don't see how there could be when I got that information this afternoon. And sent the email to her after, so that I could substantiate what I found from her. What I summarized from our conversation. So, going back to what I have found, so what I summarized for you as far as the history of the property. If there is a claim for a separate dwelling unit prior to the Reagans owning the home, and I do not agree that there was, then it was illegally constructed without permits or knowledge of the town after the CO and septic permit was obtained. The conversion of original garage to living space, which I had thought was said, but today it seems to have not been converted. It is a garage, that I'm unsure of, has not had associated permits, if that was converted as well. And any claim was abandoned by their not pursuing its use. Mrs. Reagan's indication that they did not intend for it to be rented. They didn't rent it. As far as the address goes, I checked with Dave Thorne, engineering technician. He has been with the town for around 30 years. He's charged with supplying official addresses for dwelling units for the town. He assigns official addresses. The property has a single address of 1005 Kensington Road. And to note, it has been my experience since working as the zoning officer since 2012, that when an address is requested for a unit, he checks with both the assessor and zoning to verify that it's a legitimate and allowed unit. And if there's permits or come up down the pipe, that's the point when he also gets a request for a unit. A permit requires a zoning sign off to establish an additional unit, so it's, Dave assigns addresses. There was, they also would have had the option to rectify this in accordance with the current zoning, or there is an option to rectify this in accordance with the current zoning regulations, as we have a provision for an accessory dwelling unit in the R43 zone. It's a special permit by the Planning and Zoning Commission currently. So there's a way to remedy. And while the basement may be too large to meet the regulation's maximum floor area, that may also be able to be rectified with a variance or committing a portion of that space to general household use, storage for the upstairs unit, whatever. So I just wanted to note those items. Now I'm going to move on to some of the things that were said tonight. And several items mentioned by Attorney Griffith or Mr. Mitchell. As I already said, the basement garage door. Then go back to Mrs. Reagan's comment as well, that the subsequent garage, which had a permit up on the upper level, I believe, she assumed it was intended as an extra garage because the kitchen window looks out into it, and she can't imagine that she when she at the house could not imagine that you would design a house with a kitchen window that looks into the garage. Basement plumbing. I have no challenge to the permits that indicated rough plumbing was installed. Accommodating future basement sinks and or bathrooms is not unusual, but that doesn't mean it's a second dwelling unit. Same with basement exterior access. It's a typical situation found in many houses. You have a walkout basement, there's frequently a door to the outside. Keys and locks, they can be changed, they can be added. No permits are required to put a lock on a door. There's an interior staircase. We have seen situations where dwellings or rooms could be rented and they install a lock. And, it's another zoning issue when they rent out rooms and houses separately, but, no permits are required to change a door lock or change a door to be locked. And repeating, access to above grade areas of basements is not unusual or indicative of a use as a separate dwelling. Going to the census, I do not know or have information with regard to how the census establishes the mailing address or gets that information, but it possibly could be by request or by an individual reporting that they, live there, as the 2016 occupant might have done. But the town, specifically Public Works Engineering Division, technician Dave Thorne is charged with assigning address numbers and verifying that there was not one. And we searched that. I searched that. Remember, the census strives to count all persons and encourages honesty in order that they get accurate numbers. And I'm going to read something I just pulled up from the census site. It's census.gov, why we conduct the census. And they highlight the census, when my search highlighted, the census aims to count the entire population of a country and at the location where each person usually lives. The census asks questions of people in homes and group living situations, including how many people live or stay in each home and the sex, age, and race of each person. The goal is to count everyone once, only once, and in the right place. So, where, that does not tie it to zoning allowing the place or the occupancy or anything else. So again, like the assessor, the purpose of their data is not zoning regulation. It doesn't tie to it. And I am going to reiterate that I recall that he asked to pull permits, but was to get separate utilities and upgrade electrical, and he was refused separate permits, and the issued permits were modified and noted as for single family back in 2016. I believe those permits were issued. Again, that's in they're in the notes, in the record rather. Room rent, and you talked about room rental. Room rental is different than an apartment, and as you know, this board sometimes sees their location on a property, but we often see with permits that the installation of separate garages and separate access points is no indication that there's a separate apartment. My courtesy letter indicates that the apartment was not found to be and does not reflect actual use, only sale as such. And again, due diligence would have found that letter that said the apartment was not legal, or when we saw the real estate listing, and it was discussed several times with this owner, including when he came in for those permits, and he could have appealed appropriately then. They're asking for a lot of inferences as an apartment between two family and in-law and practical use over time, and you have those differences between the nomenclature, I think that's the right word, of in-law versus multi-generational use, and a house having amenities that are used by the same family, and not as a separate apartment. Again, going back to Commissioner Mazzata's question regarding the assessor and the square footage, I concur that I don't think that, I do believe the square footage of a main living area, the above grade living areas are indicated as the square footages for that number that appears on the property card, but the finishes and the uses are appropriately taxed if they exist and they are taxable. And if an apartment or the amenities that form an apartment become a violation, or we'll refer to it as the term we use today as the dwelling unit, the amenities, that the use of them becomes the violation when it's used and rented separately. And today, we don't allow those amenities, the permits to be issued for those amenities to be installed as such, because we have found that there were second kitchens or basement kitchens that, well, then maybe they put in a bathroom and they got a permit for a bathroom, but who knew there was a kitchen? And then a new owner comes along or whatever, and they decide they can rent it, and that's when it becomes a violation until now. Now, our policy is we don't allow the permits to be issued for something that creates a severable dwelling by definition, to be clear. I think I hit all the points, but I'm open to questions. Maybe clarification on something I've said.
One clarification, right?
Jeez. She's asking.
Any other comments?
I-
You're all set.
And
This CO from 1970, this was after the fire,
yes,
which is a proof for occupancy as a single family dwelling.
Yes. Exactly.
So,
The premise for my establishing, it was a single family occupancy and the septic system went along with that at the time of the research for the order in the first place.
so this was between 1990 and 2015. That she owned it.
The
Reagan's.
Kim Reagan.
It wasn't used as an apartment, as far as I can see. It was never used in an apartment for 24 years. I mean, your brother-in-law's living downstairs, that's fine, that's not a big deal, but I mean, that's not considered an apartment.
My conversation with her indicated that she did not feel it was a rentable apartment,
Right.
that they had a family member living in.
So if you're going back to my original question, 24 years, it was never used as an apartment for 24 years.
Can I just ask
Okay, so let me address that for a moment. Okay, so,
Well, yeah, Jennifer, maybe Jennifer, you wanna-
Let Jennifer talk.
Yeah.
Let Jennifer talk.
So in just looking again, because I have the deed from, when Attorney Griffith offered the deed from the Reagans to the Mitchells, into evidence when we went up for the hearing on the merits. So, the deed reflects, again, that it was recorded with the town. It's not. And the deed reflects it was recorded. On August 13th of 2015, and the letter that was sent, which is return of record 3B21, is dated March 9th of 2015. I guess I have the question because I know it seems like we're focusing on this period of time when the Reagans owned it now with the information that we have from Mrs. Juicy. So did you, and I'll ask this through counsel, did your client know, did the Reagans talk to him about the fact that they received this letter? Because that's a long period of time. I mean, that's March 9th of 2015 to when he purchased it, August 13th of 2015. I guess I don't understand, I'm concerned about this, just from perspective as their counsel, that we don't, they haven't received anything from the Reagans, and now she talks to Kim, and she's saying, I don't understand sort of why don't they have anything from the Reagans, why wasn't there an effort to have a conversation?
why don't we
I'm
have,
confused by this,
why,
because they did own it for 24 years, and
didn't we have a conversation with the Reagans?
yes, did you? I mean,
No. I think we had-
She was in a bad, her husband dumped her. So she was in a bad way. I mean, we talked to her. We don't know nothing about this letter. But at the same time, in answering your questions that it was not rented, she didn't need to rent it. She had her nephew or whatever living downstairs. So she had no need to rent it out but the main thing here is it was not abandoned. And we've established that it was set up for it at the time of the zoning allowed it, just because, and I wanna make one other point very clear. When I pulled that permit, it was to separate the utilities. It's clearly said that. When I got back there and zoning got on my case, she flipped up a piece of paper that had the permit on it, and it said, single family with a big red stamp on it. I didn't pull that. Why would I pull a permit for separate the utilities if I wanted to have a single family house? Doesn't make sense. And the problem came after I started pulling permits. So the whole thing here is I'm just trying to comply with the law, and what law did I break here?
Can I just reiterate that, and call back to your attention, the 1968 to 69 permits that indicate it was a one family without the basement fixtures so therefore, if those fixtures and those amenities were there prior to that time period, it was without knowledge of the town. And we can't find a violation where we don't know it exists. It was in 2016, 2015, and 2016 that we found out there was an apartment. If we don't know there's an apartment, we don't have the right to just go in. As a zoning officer, I cannot go in and to randomly any apartment, any house and say, I need to check your house and make sure you don't have a separate apartment. I can't do that. We don't know what's done without permits. What we have is a system that when a permit comes through, it's reviewed by multiple departments or multiple layers of people. Back in that day, the building inspector, I believe, was simultaneously did the zoning as well. There was no planning department at that time. And they, but again, I don't want to speak exactly to that time period. I didn't search who did that job. I did not search. But it's been my experience to see things written by the engineer and by the zoning officer, the inspectors related to zoning violations that came from the ZBA at the time, or the zoning boards at the time. Again, in 68, when only a single family was allowed, it was a one family. That's what permits show. That's what the town had knowledge of. A single family home, no knowledge. Or noted into the town records, the building department record, at the time we got a report that it had potential for an apartment in a sales listing.
Notwithstanding no knowledge, and we don't know that back in 1958, we do know that it was used from 1960 to 1981. We have a sworn statement. And secondly, we have an unsworn statement, but if you want to consider this unsworn statement, and actually it's not even a statement from this Kim Reagan, it's it put in words of the ZEO after the fact, put her in her own words, okay, what it was. But let's take a look what was said. And it says, when the Reagans moved in, quote, finished basement had attributes of walkout apartment with a galley-style kitchen, full shower bath, dining area with fireplace, and a living room. The kitchen had a stove top and a wall oven. What that tells me is now we're filling in the gap between 1981 and 1991. We now know it goes back. We don't have, and that's coming from this Miss Reagan, okay? We don't know if the brother-in-law paid rent under the table, whatever. We don't know any of those things. But we do know this, that the Reagans, when they listed the house, we know that they listed it with an apartment. And I would say that to the extent that is now in front of the board, again, she may say something there, but there is not a intent to abandon the use because they still went ahead and listed it. And she was a part of that. And it's a part of the record, plus it's on the tax assessor's record. So there isn't, I guess this is an attempt to show abandonment. At this time, at the prior time, it doesn't work. And back in 1970, it doesn't work because we know by a sworn statement that it was actually used during that time. And it's interesting to me that the zoning enforcement officer didn't address that at all. So that doesn't make any difference. It makes a huge difference here. And zoning enforcement officers, if there's a non-conforming use, no, they don't have, and that's why we appealed it. No, they don't have a right to have someone who has a legal non-conforming use to cease and desist that use. And that's the gist of this argument here. And I just want to make it, again, I'm going to point out for the record, the town of Berlin sets the rules that we were required to follow as far as submissions. Okay, we did that. Now, I did submit some documents tonight. And it was, again, I called Attorney Capola before I did it. I wanted to be transparent. And I feel that, we've been really, ambushed by this tonight. And I just think I'm just telling you for the record, I think it's wrong. But to the extent you're going to consider it, we'll address it and have.
Can I ask Attorney Capola to walk the board through a little bit more detail on where I focused before on the definition of abandonment and where, specifically, I'm kind of getting turned around because the town used the word, that they're asking, the appellants are asking for a lot of inferences, and that's in this definition. And I just don't know which way this is going. So abandonment, to establish abandonment, the intention on the part of the owner must be to relinquish permanently the non-conforming use, but then I feel like it's on the other side, it says the intention of the landowner is an inference of fact and it's not reviewable unless it was one in which the trier could not reasonably make. I'm just confused by the whole statement there. Could you help us on that?
It's lawyer talk.
Yeah, I know.
So the case itself was about, if you look at Cumberland Farms, and ultimately what happened in Cumberland Farms too, in terms of because remember, this is an appellate court case, so they were evaluating the trial court's decision. And at one point, and the cases are attached to my letter, they were stapled together. But I will say this, I will offer this as guidance. If you look at the page where that language appears, where that quoting of Cummings versus Tripp, it's on page 3 of the Cumberland Farms case. It's in the writing. I marked it. Because maybe this is instructive to answer your question, Mr. Woodson. In addition, it's the third paragraph, again, right-hand side of the Cumberland Farms versus Zoning Board of Appeals appellate court decision, page 3, third paragraph. In addition to holding that the use was not a pre-existing non-conforming use, the board alternatively held that the use was abandoned. The board held, however, that there was substantial evidence in the record that the use of the property as a gasoline station was suspended for reasons beyond the owner's control for a reasonable period of time. Accordingly, the court held that the board's finding that the use had been abandoned was illegal, arbitrary, and abuse of discretion. Although we do not disagree with the court's reasonable interpretation of the evidence, we nonetheless conclude that substantial evidence existed in the record from which the board reasonably could have found that the Bongiorni estate had abandoned the gasoline use. And then the court goes on, the appellate court goes on to recite the facts that they relied upon in that specific instance. That it talks about the gasoline, talking about a gasoline station use, apartment use. But they talk about how the storage tanks were removed, the gasoline storage tanks were removed from the property. At that time, the property was owned by that particular estate, then they sold it, and they go on. So I will say this, I don't know that you're not in the same position as the board in that matter, because I think that, you've heard, I think, compelling arguments on both sides. You know, it's difficult, there's a lot of information here. I think you have to focus again, you've gotta start from the premise, and I think Mr. White said you started with this, you went through the proposed findings of fact. I think just going back to my initial comments to you, you have to start at the beginning. You have to start from that moment in time, and counsel has certainly shared with you his client's position of what that moment in time is. When the use in question, they're saying was illegal, pursuant to, and they're relying, and you didn't touch on this, David, but I'll be along with that. They were relying on, and this is of record, because it's in the things that you received, they're relying on the definition of dwelling. And they're saying, you know, at the time that the regs were in effect and this structure was constructed, this use was permitted, and then it became illegal in the 60s, and they've, you know, made representations that, you know, that this use was continuous and was not abandoned. And I think that you need to, again, evaluate, because it's the direction of the court, first and foremost, do you agree that there was a moment in time where this use was allowed, that it was in place at the time that the use was allowed? Then, you know, it became disallowed by a later zoning ordinance or regulations that were adopted. And then you have to make a separate determination if it was continuous, without clear evidence of abandonment. And again, I think, and the court does use language in the remand. He talks about, you know, reasonable inferences being made, because you are the finder of fact in this proceeding. And you also, though, you also have, you know, again, the instruction of that language from Cumberland Farms, again citing Cummings versus Tripp, and that was a Supreme Court case. But abandonment is a question of fact, which implies a voluntary and intentional renunciation. A mere discontinuance of the use where there's no intent to abandon is not enough. The intention on the part of the owner must be to relinquish permanently the non-conforming use. So, and in terms of that last sentence, you know, again, our intentions always inferences of fact. When you're standing as the body or the individual, as the case may be, right, determining somebody's intent, you are making inferences from the facts as they've been presented to you, right? I think that's all that it needs. And it is not reviewable, is what they're saying, and this is why I read you that second paragraph, that next paragraph, and it appears in the decision. It's not reviewable unless there's no facts from which you can reasonably infer. I mean, that's all the court in Cummings was really saying. Like, if there's no facts in which you can reasonably infer, again, that the property owner has in fact intended to abandon, permanently relinquish, then it's reviewable because you're clearly now drive that. So I hope that explains. I know it's a little bit muddy. I tried to do the best that I could at 10, but we got 10:15.
Well, can I just redirect to CEO, so is it the town's position then, after hearing that, that the abandonment, you're considering the abandonment permanent based on the lack of them trying to remedy their own situation in all of the or correspondence of their ownership, the Reagans? Like, and all of the sort of tacit places where we said single family, we're notifying you of a non-conforming use. An application that says that there's nothing in the basement. I mean, is that where you're saying that from your perspective that is a permanent relinquishment?
What I'm saying is if there was the records that from those officials that were gained access to the house indicated that the basement wasn't finished. It was rough plumbing. It wasn't finished as a dwelling. If you go back to ROR 3B1 in 1955, it says it was one housekeeping unit. If you go back to ROR 3B14, the septic installation, families, one. The 1970 rebuild permits refer to one, one dwelling. The town, if there was a second dwelling prior to 1970, I would have looked at this record and said, well, that was relinquished in 1970 when they applied for permits for a single family dwelling to be built. Rebuilt, but built. There was no acknowledgement that there was a second unit on the property by the owner. It seems to me that there was an indication that they may have been trying to stay under the town's radar with any apartment that they may or may not have rented. If they didn't rent it, it wasn't against the rules at that time. As Chairman Franklin commented, there were periods of time, up until fairly recently, where what we consider what is defined as a dwelling unit, which is eating, sleeping, and bathing facilities, separate eating, sleeping, and bathing facilities, was not, is no longer, we don't allow it to be installed anymore. But there were plenty of years that you could install those features, but it being an apartment would have had to be authorized. And in 1970, their applications that filled out by the property owner and or their contractors or whomever, I can look to them to see if I could recognize signatures, indicate one family. That's after the time that this was a single family zone. And if they had a claim for nonconformity, it should have been claimed to the town at that time to continue it. There's no record that shows that. There's a record that shows one single family. Multiple records, both the town and both the building permit record and the septic record.
Where are we?
Thanks, Tony. Tony is the one, or rather Chairman Franklin has to acknowledge,
Oh,
that's
yeah,
each
go
to
ahead.
speak.
I have a question. You mentioned two different ways of remedying that for the Reagans or whoever. Could Mr. Mitchell go through that process of remedying it at this point?
So I do not want to speak for Mr. Mitchell, but there is a difference between a two-family and a unencumbered apartment versus what the zoning regulations allow now is the special permit use for an accessory dwelling unit, and it does have to meet certain parameters, and that includes either an age restriction or a income restriction on it. So I think, and again, I don't want to speak for him, but I think he's looking or the determination that an unencumbered second dwelling is allowed.
Question. When me as a contractor of 30 some odd years, when I go to the town and I pull a permit, I ask what the zoning is on that area. Okay, that is not primarily, sometimes the people, the building department fills that part in. Because the builders don't know what the zoning is unless there's an issue. Okay, so it's kind of a moot point. It's like when I pulled the permit and had the separate utilities. That's why it was questioned on why I was pulling such a expensive permit. Usually service is $2,000. I pulled a permit for $8,000. Okay, this is what started all the flags. As far as trying, you know, it's very hard to get any records in the town. And I don't know if you're aware of it, but most of the records were destroyed. Okay, there was I believe the fire marshal told me that a gauge went bad and flooded out most of the records. So it's very hard to come up with accurate records other than people. So I throw that out there, but at the same time, I think that we've proven that even with the information that was given here tonight, that there was continuous use. And it wasn't abandoned because it's still an apartment and it's still, I mean, changing the countertop is nothing. So it was continually used and it had the original stuff in it. So I failed to see where we did not keep in compliance with what the law said when it first started. It wasn't abandoned as far as I can see, and even proven that Mrs. Reagan she kept the use. She had her nephew down there, she didn't need to rent it out. Still being used.
Can I address the records at the town hall from my experience? So the building department records are kept in file cabinets in the building department. They, to the best of my knowledge, we have the blueprint from plot plans from that dated back to the 50s and possibly some in the 40s when when we started the permit processing, zoning, etc. Some could be even older than that. The records that were damaged by a leak in the town manager's office that went down to storage that was in the basement were planning and zoning commission records. And the destruction of those records that were damaged by rain, or by the water rather, from the pipe were sent to the state lists of those records and would have been actions by the Planning and Zoning Commission, the Planning Commission, or the Zoning Commission, or the Zoning Board of Appeals, and were authorized to be destroyed and not, the plan was to freeze them and bring them back if they could, but those are not records that are relevant here, because this is the building department record that's showing us the history of permits. And those I do not believe have been affected by damage at the town hall, the Planning and Zoning Commission, Zoning Board of Appeals, before it was Planning and Zoning Commission, it was a Planning Commission and Zoning Commission. Those actions of theirs, et cetera, are all recorded in minutes because they're commission meetings and they're the actions you take otherwise, and those are in minutes and in filings on the land records, et cetera. So there's other places much of those permanent records are. The maps of maybe drainage systems that were put in and other things that go with site plans may not be available there, but those plans are then reiterated in a building department record when a building permit is taken out. The building of a house would not have been subject to our department's retention and having those records. We wouldn't have had them, they only went through the building department for a single family house. they wouldn't have come to the Planning and Zoning Commission.
You seem like savvy real estate guy owning several properties. Before you bought the house, did you do any due diligence?
Yeah, I did, that's where I found that they were renting out the apartment below.
You never pulled this previous CO that says
Oh, the
single
letter
family?
she's talking about, I never saw that.
Oh, this 1970s CO, the likely would have come up, never saw this?
No, I never researched it that far back because it had, in looking at the, you know, in the course of things and looking at, as an experienced contractor, looking at what was there, nothing had been disturbed, so it was grandfathered in. And it doesn't matter what, you know, like I said, when you pull a permit, the guy goes up there and he's, well, how much you gonna pull a permit for, or whatever, I'm gonna do some plumbing. They don't say what the zoning, I mean, it matters now, but to a contractor that's going up there to do a repair or do something, he doesn't care about the zoning. All he cares about is pulling the permit. And that's why I'm going back to the original plumbing and everything in the house. Nothing had been changed.
I'm a real estate guy too, and we do our due diligence, I'm not worried about zoning, I always look for the CO of the building and this, so you never looked for the CO? Make sure it was occupiable or anything?
The CO would have been in 58.
Well, it was redone in 1970 according to this after the fire.
Yeah, there was a fire. I think the fire marshal brought that to my attention.
So that the CO from 1970 is pretty clear as a single family dwelling.
Yeah, but yet you have a sworn statement, the people that lived there, that used it as an apartment.
Illegally, possibly.
They rented it out. I mean, anything's possible, but the history of this is going from day one to even to the letter of the Regans. I mean, it has not been abandoned. If you know, the important time is this fire, okay? It was used right up until the 80s and beyond, as proven by her. She didn't have no use for it. I mean, you're only gonna use a house what you wanna use it for, if it's an apartment or not. But it was not remodeled. The way I understand it, someone would have to pull a permit and take out the kitchen and remodel it, or change the basic structure of everything down there. None of that was done. That is the point of what I think the flavor of this law is trying to say about grandfather clause then. If somebody would have changed the plumbing, the basic structure, how it was set up, I think I wouldn't have a snowball's chance in hell. But this right up until the point of now, it's been used.
I'm a little confused, and if this question is naive, forgive me. Just in everything here, do we have any documentation that shows this was ever a legit two-family house? Cause all this talk about the plumbing still in my head, that's the same thing as a finished basement for extended family. Like I just haven't seen anything that shows this was actually a two-family house.
I think the point is that they don't have to because they're claiming a non-conforming use as of 1962. So the two, going back to my original comments, the key points are, do we agree that it's non-conforming? What does the town think about that? What do we think about that based on the evidence? And then if it's not conforming, do we agree or not agree that that non-conforming use was abandoned?
Certainly no one remedied it, made the attempt to remedy it due to all the subsequent.
But even as a
documentation.
non-conforming use, it was never listed as a two-family house. It didn't have to have 2 meters, it didn't have to have 2 furnaces, I know that, but even as a non-conforming use prior to 1960, it wasn't really listed as 2 addresses.
Nobody claimed it, right? So to the town's point, it was like
Only one
all
address.
these times that they could have claimed the non-conforming use, they chose not to. And so again, I also feel like they were trying to go under the radar and they didn't outright claim the non-conforming use, but to me, I don't know if the law And what the judge is trying to get us to focus on really cares about that. You know, whether they claimed it or not, is there a non-conforming use based on the evidence? The physical evidence, I guess.
I don't know, the 1970 CO seems like physical evidence to me.
But you had somebody that lived there and used it, and it was well known.
Two-family houses have two addresses. You know,
A
74
and B.
Clark Street and 76 Clark Street.
Or A and B.
Right, but that they never did. It never did in any of the records.
I was just gonna say that the town did not
That's the part
issue
that
a separate address,
I didn't even know this guy existed.
I mean,
Did you?
and it doesn't appear the town had knowledge that there was an apartment that was rented.
I don't think we can then go and approve something, like an illegal action, like making assumptions if someone was renting it in the past. All of this says it was a single family, and even if he was renting it, I mean, how do you justify an illegal action?
Can't.
I mean,
You can't.
It's not illegal if it's non-conforming.
That's the point.
If a non-conforming use, it's not illegal.
But just with regard to that, if and Jennifer Coppola, counsel for the board, just focusing though, again, I think David, maybe you need to go back through your argument with regard to the piece of it before 1970, before the Sears were in there. Because what you're relying upon, again, you're go back through with them your legal argument, because you really didn't do that tonight. The legal argument that you have that it was a lawful use and that it was an actual use.
Well, the lawful use is in the farm zone, you could have up to a two-family dwelling. You have a building structure that was apparently approved by the town, okay, that was basically the way it was originally designed. That it was designed showing a basement, a basement dwelling with entrances cut through the foundation and a separate carport, again, the original poured foundation. And you have the plumbing then connected. We know back in 1960, which is pre-1962. So again, it was, notwithstanding that, what the permit said per se, or even the CO, it still was allowed, it was permitted in that district. It was up to two-family. And from my understanding, very common in a farm zone back at that time. So again, the use was there. And we know that the original owner who built it also, built in the cabinetry there. We don't know for that the year or two that they owned it after they constructed it, but we do know that the Sears, when they moved in, they continued it for over 20 years in that use. That was prior to the zoning ordinance change, and it was not in violation of zoning, because you could have up to two dwellings at that time. So it was permitted.
And another point, I have to ask Lorraine, how many zoning officers and building officials at that time even give a hoot about it? I'll bet you there was only one in the whole town that did the inspections, the zoning, if there was much of zoning. At the time, it was not an issue. They didn't care, because it said one or two family. It was a three-family they were concerned about, not a one and a two back in that day.
And I just reiterate that amenities, and I just wanna reiterate this, amenities did not indicate it was a two-family. If the amenities were installed at that time period, again, that's presumption of, the record we have shows the 1955 CO, ROR 3B5, I think. Claimed on the permit as a one-family. And again, in 1970, that CO states it was a one-family. Two-family, if the regulations allowed two-family, it should have said two-family.
So this was abandoned before 1980, it was abandoned in 1955.
This is the original.
Well, the 55 is the original permit for the
It
house
was
to be
abandoned in
built.
55, as far as I'm concerned, because that's what it says one family. I mean, you can look at it from that perspective too. You know, somebody put a permit for this thing and they said it's a one family and it's 1955. That's it.
But it also says that it wasn't complete.
It wasn't what?
Wasn't completed.
I know, but I mean, it's a certificate of occupancy. My God, I mean, that's a legal document. You know what it takes to get one of those when you build a house?
Doesn't it have to be
Back then?
complete to get that? Substantially complete?
Substantially complete, except if you're.
You think that you would get that on a permit today? I don't think so.
How come there's 0 garages on it?
Hey, if it was livable, they allowed people to go back in.
September 29th, 1955. Years ago.
It shows it's always been a single family apartment.
I mean, I feel like my hands are tied. You know? Any other comments? All right. Have none? Does anybody else have any other?
I think I'm exhausted.
Counselor, what do we go from here?
Well, I think you have to go through, first of all, you gotta ask if there's anybody, there was somebody signed in, are they still signed in? I saw her, but since you've been putting.
That's our recording secretary.
Oh, okay.
Oh, yeah.
You should still.
That's you.
Hi.
They don't,
Mr. Chairman, you should still call for any public comment because it is a public hearing.
Well, yeah, if there's anybody out in the on the web conference
or telephone.
or telephone,
We don't-
if
we
there's
don't
anybody who has any comments, please give me your name and you have the floor. Going once, going twice. Any comments? I don't think that, yeah, I think the only person out there is our recording secretary. That's probably recording this on the. Is that correct?
Yes.
Yeah, she played.
She's waiting.
So I guess at this point, I
I think both sides, excuse me, Mr. Chair, I'm sorry, Jennifer Mulligan, counsel for the board. I think both sides are indicating do not wish to offer anything further.
Well, the town has regulations for apartments. Under the law that they have right now, we do not comply. I felt that it was a non-conforming use. And, under what circumstances would we have here? And I don't feel that that's gonna hurt the town. It's not like anybody can produce all this information and replicate it 50, 60, 70 years prior. So it's not like this is gonna be a wild horse that's gonna get out of the corral and a bunch of people are gonna be signing up as two-family houses because of it. This is not setting a wild precedent. You know, I'm a commissioner in the water and sewer and we deal with few things. But, this is not anything that's gonna set any precedent and it's not gonna hurt anyone. But I felt that we've shown that it is, good continuous use. And it was legal.
I would be concerned that other people may look at this and have amenities built into their house that then will create zoning concerns for our department and enforcement issues where people could not understand the time that has gone into this and the evidence presented. And believe that their apartments could also be used when they were built and used as amenities in a single-family home, or installed in a single-family dwelling as indicated on the 1955 and 1970 COs and not, and stay under the radar, because you just don't, and then it's a zoning nightmare. This evidence is showing that it's a single family dwelling. I don't wanna reiterate myself again.
I'll just say non-conforming uses to some extent are under the radar, just by virtue of it.
And this is something back 1950 something. How many homes were built here in Berlin?
Well, we've got to come up to a decision here as to, is this, are we upholding the zoning enforcement officer's decision in terms of, I think you stated it better, Corey, at one time.
I think the judge wants us to actually come up with the findings of fact.
Right.
And we've got a guide from the appellant that says, here are their proposed findings of fact. I don't know that those are the ones that we might come up with, but we need to have the findings of fact support the decision that we're gonna make after deliberation. So, I mean, it seems to me like we've got our information, we go into the session where we discuss our thoughts. And we have, I think, is that our deliverable to the judge has to be basically this single piece of paper that says, these are the findings of fact. And this is why we either support or deny the appeal.
Remand.
Yeah.
So
Correct.
yes, so again, just going back to page 2 of my letter, I think, I mean, it generally comes down to two things, right? He says, you have to consider the timing of the construction of the basement apartment in relation to the applicability of the zoning regulations as they changed over time. Again, they've offered to you that moment of time when they're saying this was legal, okay? So you have to consider along with that, was it in use? Was the use that's an issue in use at in the time frame they're saying that the use was legal? And then they have an argument of when it became non-conforming, and they're saying that the use continued throughout. So you've got to consider, I think, first, that component of, was it legal, and then it became illegal, and thus a non-conformity, okay? And then you have these issues related to use. So it had to be an actual use at the time that it was legal, and that use had to continue and not be abandoned. And again, we've got the language on abandonment and what the components of that are. And you know, I mean, whether you do it by list or, you know, you articulate cogent reasons, in the action that you're taking as collective reasons of the board, if you have, you know, agreement amongst you. I'm not gonna tell you you have to list out 1, 2, 5. But you do need to provide reasons, and he's given you a map of what the components of, you know, your reasoning should be. He's mapped it out for you.
So do we need to, I know it's getting late, but do we need to,
Close the public portion of the hearing first?
pardon me?
Do we need to close the public portion of the hearing?
Well, do we need to close the public portion of the hearing and
Resume another day.
then resume another day?
Yeah,
Listen, I think
I know,
you've taken a lot, and again, I would encourage you before you close, if you're going to close it out, if there's perhaps you'd like to inquire any other comments, and I think it's entirely fine if you wanna conclude, the public hearing and deliberate another day, if that's, again, given the lateness of the hour, I guess that's okay. You have a lot of documents, that you've received. And you certainly have taken a lot of testimony.
What's your preference?
Just before you go on, I'm sorry, I didn't actually see that. So let's we're gonna take a pause.
Oh, that's right, she went out.
Oops.
Okay.
Apologize. I was looking at folks in front.
So it took them a year to finish that.
Mr. Chairman.
Oh, she back? Where is she? It took almost a full year to get that building from it. It was
Yeah, so October to September?
October 54 to September 55. Chairman, Commissioner Mazzata, we've talked to, and we know it's getting late, and we can close the public portion of the hearing at this point if you want, and get together, or meet again to put together our findings. And that would be public as well, I guess.
Yes.
That's public, so.
Yes, deliberation is public. You just could not take in any new evidence, so again, I encourage you, if you have questions, we should ask them at this point.
I
Before you
still feel we
close.
should take this lightly.
What?
I don't feel we should take this lightly and.
No, but it's getting late and.
Late and tired and, yeah.
I'm thinking that if we close the public portion of the hearing, if there are no other questions, then we'll have to reconvene, and put together our, our response to the judge's remand.
Is this something that everyone is in agreement with?
Well, I wanted to see, what you folks, commission members, were okay with that. I didn't wanna, just ram it, I didn't wanna say we're gonna do this, this, and this. I just wanted to get your thoughts on if that was, if that sounded good.
Indifferent.
I think, Mrs. Juicy has something to say.
I read my notes into the record, but did not, because they were notes I made as a presentation. But not being a lawyer, never having done a remand before, did not come up with the proposed findings of fact as the attorney for the opposing side did. So I would like to take these notes as read and enter them as Exhibit A and distribute them to the commission so that you have what I said in writing in front of you to deliberate with. If you, well, I'd like to do that regardless, and then if you decide to hold it open, so be it, you have them. And if not.
That's also an option, I guess.
Yeah,
to hold
hold
open.
it open.
Not hold it open, I'm sorry, I meant to not make a decision today, I meant I could just, we could distribute them as long as they're an exhibit, correct?
Yes.
Am I correct?
So let me just say something. So in COVID world, and this is something that you folks probably don't know. So there is an executive order, it's Executive Order 7B, and it governs what we're supposed to be doing from a FOIA perspective, okay, when we're holding remote hearings. So it's one of the very early executive orders that was issued. And that's why we have this obligation of posting meeting materials on the town's website. And if you read at the top of your notices and your agendas, it's indicating that the public should submit, any interested members of the public should submit any documents we request that they submit in advance so that we can comply with the procedures. That does not mean that people cannot submit in a meeting, okay? People, especially, you are, like, if he came with boards and everything else, I mean, we would take that in. It's just that we're trying to post as much in terms of meeting materials as we can. And anything that's received in the meeting, and I told Attorney Griffith this today about his photograph copies that he was coming with, those will get posted tomorrow morning, because that's our obligation. Anything that gets taken in does get posted. So, it's not like people are forestalled, just so that you understand, in the COVID world, people are not forestalled from coming to a meeting and offering things as they. So it's fine for you to take in whatever.
What's that?
I said it's fine for them to take in whatever.
I don't know but if we have any other questions, we can get them answered. We did have a lot of testimony. I feel like we could probably make an informed decision with some additional pieces of evidence. We might want to consider asking for a sworn statement from Mrs. Reagan in her own words. I guess I would appreciate a new town proposed finding of fact.
Okay, so you can continue this if you want, or we can ask for those items and close the hearing.
I discourage that,
Yeah.
because if if there's things you want from both sides, I think they each should have an opportunity to review it and ask any questions that they have about it or make any statements, much the same way that Attorney Griffith reviewed in the meeting the email and he offered you some argument, some perspective, so I
Sounds
don't,
reasonable.
I discourage
Sounds
that.
reasonable, that sounds reasonable too.
And I also would request the opportunity from the board, if you're gonna keep the hearing open, and if there's a possibility, or even without the possibility, of a sworn statement from Mrs. Reagan, that we have the opportunity to submit additional evidence in regards to that. Because we didn't know about it until tonight.
Sure. That's reasonable too. That's good. When can we continue?
The next meeting, do you have oh, I have a calendar on my phone. Find it. The next meeting should be Tuesday, November 24th. It's the Tuesday before Thanksgiving. Or there's the option of a special meeting. The issue with establishing a special meeting right now, as opposed to asking me to figure out a special meeting, is the availability of this room that has the technology and the distancing parameters. This is also available downstairs in the Board of Ed conference room, but we do have conflicting dates, because as you can imagine, the boards and commissions met in many rooms throughout the building, and we're all scrambling to stake our claim. Luckily, this board, Planning and Zoning Commission and Town Council have this room from the beginning of the year. So for our regular meetings, we should have this room for the most part. However, I do reserve the ability to make sure we have a space without you identifying a set in stone date. If you want to have a special meeting, perhaps you can come up with a few dates for me to try. I know November 10th, the rooms are all occupied.
How about November 16 or 17?
Say November 22nd.
The 24th?
Oh, okay.
We're pulling up the town calendar. I can get a good idea, or somewhat of an idea, if rooms are almost surely occupied based on who's having meetings.
That last week of November is Thanksgiving weekend, probably not a good week because there's ZBA is on
Well, you
Tuesday.
do have the meeting scheduled for the 24th. ZBA does meet that night. The 17th currently shows no meetings. That doesn't mean there are none, but it shows none. The 18th shows the police commission is meeting. I believe there's a conflict there.
19th.
Planning and zoning's up here. I don't know if the Board of Ed room would be otherwise occupied, but I'm otherwise at the Planning and Zoning Commission meeting. I have a conflict
17th.
with the other board.
On the 19th, you have
On the 19th, we have the Planning and Zoning Commission meeting.
So she has a conflict the 19th and the 5th.
And the 5th. I already know the rooms are occupied on the 10th,
10th is
Tuesday.
occupied.
Yeah, the rooms are both taken. I tried to get them for another meeting.
12th is also, or
I'm good, any of them.
there are several meetings on the 12th. I don't know what room availability will be. Probably could get a room.
If you wanna get a couple of dates, just email them out to everybody.
If you can all agree you're available on and opposing.
Attorney Griffith and I are not leaving the state, so don't worry about that.
You can't even go to Massachusetts anymore.
We don't wanna go to Rhode Island.
Seventeenth looks like the best one so far. You wanna plan the 17th and then,
Yeah, can you, I would ask that you give me 2 or 3 dates because I am very concerned about, and it takes a lot to get hold of each of you and
So if we can't do the
cross-reference.
17th, why don't we just do the 24th, since we know we have the room? That's a sure shot.
Corey's. No, I'm good on the 24th. Okay.
I mean, it's a sure.
24th is good because we can always, unless you have a lot of applications, we can take care of our applications up front and then take care of the rest of it. Go for the 24th.
We expect not to have the carrier appeals.
Yeah,
We expect that will be eliminated.
Well, that's gonna probably go away, so maybe, there's a possibility that you may not have that many applications.
So just forget the 17th and just continue
Go
the
for the
24th or
24th.
still continue, or still try the 17th, I'm sorry, I just need to correction.
Let's go for the 24th and make it easier for everybody. It's only a week.
And we're looking to enter into evidence in between now and then, what? You got a couple items and you got a couple items?
Maybe.
Okay.
Yeah, maybe.
Well, at least it's open, at least
Yeah,
there's
yeah.
an opportunity to.
If you got anything you want, that you feel that we can get, to clarify things.
We'll copy and distribute any of the exhibits we don't already have copies of. As soon as we can to you, because they're from tonight, we'll try to send those out this week from our office, they'll be mailed. And then if I understand correctly, you'd like a sworn statement from Kim Reagan, if she's willing to provide, and a proposed findings of tax by me, and any amendments from Attorney Griffith. Did I hear that correctly, or did I just make that up?
No,
Yes.
that's
Nice,
correct.
I made notes.
That's correct, that's good.
Thank you.
Okay.
Make a motion to continue this hearing to November 24th.
Second.
All in favor?
Aye.
Aye.
Thank you very much for your time.
Thank you.
Do anything else? Adjourn.
That's it.
Make a motion to adjourn?
Oh, yeah, well, continue to the 24th.
Who made the second?
Maybe second.
You seconded the motion to continue.
No, adjourn.
Adjourn?
Yes.
Anyone?
I did.
Thank you.
Yeah, everybody was in favor of that.
Say all in favor.
All in favor? Aye.
The time is 11:21, according to my watch.
You get overtime?
Yeah, it's the same, right? Time and a half, double time?
Zero.
Zero.
Denver taught me how to touch it. I don't want to think what it is.
They said, the girl was very freaked out, the idea that I would be picking up with her. She was turning around the office, I'm like, where are they? Don't tell me where.
All right,
Is there any advice on what we can and can't do in recess?
Yeah, you can't, we can't discuss anything.
No, no. Nothing's to be discussed.
Seven or
Yeah.
Unorthodox is a